May I please report?
Yes.
I beg to mention item number 6 of today's list is a portion matter, Your Lordship. May I pray for listing of this matter on 18th, Your Lordship? I
Why?
want to file an additional affidavit on important documents, Your Lordship. We could not annex, Your Lordship.
What you couldn't,
Lordship.
what you could not enclose?
One report of the, Your Lordship, local survey commissioner, Your Lordship, during earlier titles, Your Lordship, where the area in which we are residing is shown to be, Your Lordship, revenue land. That report, Your Lordship, we did not, Your Lordship, inadvertently, we missed it out.
You have the report with you?
Lordship, report two is there with us, Your
We'll see when the matter is called.
Lordship. Obliged.
Wait, Your Lordship. But I beg to mention item 31 of today's list. So we filed an affidavit. If it may please be permitted to be brought. Deeply applied.
Lordship, I will mention item number 30. Item number 30 pertains to the GST, Lordship. And I am told that Mr. GST Council is out of station. And in this case also, even the conducting counsel for the petitioner is also from Calcutta, Lordship.
Who is out of station?
Mr. Subhas Kayal, the counsel for the GST. I am told yesterday. And even the conducting counsel for the petitioner is also from Calcutta, Lordship, because he informed that he is out of station. So may I pray for fixing the matter on 25th, Lordship? Much obliged. On 25th.
Request of Mr. P. N. Sharma, matter stands adjourned to listed on to I-25th.
25th, if the matter is fixed, Lordship, then the counsel from the
Why on Thursday? Why on
Thursday?
Thursday?
26th is the,
You are enjoying an interim order?
there is an interim order.
We'll have it on 29th.
29th, Lordship. Much obliged.
This is the matter on 29th at the request of Mr. P. N. Sharma. The interim order passed shall continue till the next.
Interim order will cut. Much obliged.
Yes, Mr. Nayak.
Lordship, I'm praying for listing of a matter, Lordship, on reopening.
Why?
But if it's a press matter, Lordship, some urgencies are there, Lordship. Where application was placed for registration of 2 lease dates, Lordship, in the year 2022. But till date, that has not been done, Lordship. In the meantime, I have also filed for an application for granting NOC in respect of that plot of land, Lordship. That also has not been granted.
You are for the petitioner.
I'm for that.
This is a very special request. We have to give it. When?
Last
19.
19. Obliged.
May I mention a bill of application for civic because this is for a Lordship yesterday. The petitioners mentioned it in the morning. It's on the 19th. May I pray that it be taken up on the 18th instead?
18, there are a lot of matters. It will come up on 19th.
Then may I make a liberty from a Lordship to mention the matter on 19th to be taken as the first side. Matter pertains to encashment of bank guarantees.
I understand. Okay, we'll have it on 19th. You mention it appropriate.
Deeply.
To inform the other side.
Yes.
If I have motions on that day, I don't have, I suppose.
Very.
Because I have already passed an order fixing it on 19th.
Yes.
So it would not be proper now to
Very.
postpone it.
Very.
So let it be on 19th.
Very deeply.
You just see, it comes up in the stay vacating column.
Yes, yes.
If it comes in the stay vacating column, it will come on top.
Very.
Lordship, I beg to mention item number 49, Lord. So, Lordship, there is some difficulty, Lordship, and I have informed the other side also.
What is this?
Lordship, eviction matter.
What do you want?
Lordship, adjournment for today, Lordship, for the day. Adjournment for the day, Lord.
Why?
Lordship,
You are appearing for whom?
Lordship, petition. Lord, petitioner.
Petitioner.
Lord.
Petitioner is who? Asbot Thakur.
Lordship,
Yes, Boni.
the Lordship out of station, Lord. Therefore, Lord.
So why it has come up for orders? Think about it. Then we'll see when the matter reaches.
Lord.
Yes,
Obliged.
Mr. Gupta.
I beg to mention item number 21. I may be allowed to withdraw this petition with liberty. There are some developments going on.
What is this withdraw with liberty?
My lord, what happened, my lord, while my settlement, while my application for settlement is pending, the respondent number 5 is that the authorities have directed to hand over the land to the respondent number 5. At this stage, my lord, this petition is filed. Initially, a stay order was there that was vacated, but in the meantime, my lord, there's some process is going on with regard to the settlement. That's why at this stage, I feel that I'm allowed to take liberty.
Your stay order has been vacated.
Vacated already in the year 2018.
Hmm.
But still, I'm in possession of the land, and now the authority is considering for settlement of the land.
We'll do one thing when the matter reaches, because if you want liberty, we have to hear the other side.
Okay.
Item number 1 for Mr.
Yes, madam. How much? 1,44,000.
1,44,000 definitely.
Yes, verify and pay.
Look.
He is entitled to.
Look.
The additional affidavit which has been filed out here seems to be reasonable.
My lord, I
Not
have
so much of that. Although this is a earlier period, but the fact that you paid the money only on 2017, thereafter COVID and all these things.
Look.
Verify and pay.
Yes.
6 months.
6
Oh, this is a PWD.
PWD.
The verify. Make the PWD to account, verify and pay in terms with that judgment.
Come say that. Come say that. Look. Hold on.
Yeah.
Item 2.
May I please allotted?
Hmm.
But the petitioner is having a plot of land around 2 acres, allotted, and they are on the PNRD. There is a dispute with the respondent number 7 lot. For that, we had approached the civil court. We got injunction in our favor.
But in
Status quo. Whatever.
so that status quo would help you.
No, that help you. My grievances is only to that aspect, Lordship. In that plot of land, the disputed settlement, PNRT has sanctioned an amount for construction of PMYC.
Are you filing the case for them? For the respondent number 5? You are enjoying a state.
No,
If
Lord,
they can't construct.
no,
If there is a sanction out there, very well, the sanction will go. They can't do anything.
no,
He
there.
has to do
But
within
here,
the
Lordship,
particular.
my grievances is not for that disputed part. Lord. My grievances is only with the state authorities that they have sanctioned the amount. That amount, Lordship.
Understood. They have let us
Then-
assume Mr. Kumar, that they have sanctioned an amount of 1 lakh or 2 lakh, whatever it may
But-
be.
Yes, sir.
So they have sanctioned. But in respect to a plot where they are going to construct, respondent number 7 is going to construct. But can the respondent number 7 construct in view of the status quo?
Lordship, they are constructing, Lord.
Then in that case, regard, are you not required to move and order
Yes,
the
Lord.
land
Here,
into
Lordship,
it?
Lordship, here another dispute. Here, Lordship, the dispute is that in that case, my in the civil suit there is separate. Here, Lordship, I'm not concerning with the civil suit matter, Lord. I'm not at all concerned with the right title, anything, Lord.
You are
Here, my
concerned about the.
grievances is only
you are-
with that they, why
you
they
are
have
con-
entered into my
No,
dispute,
no,
Lord.
Mr. Sharma, are you concerned that the PNRT is losing money? You are not. Then
No, Lordship, then also this letter will later on, Lordship, this sanctioning letter, Lordship, this is in page number
no,
16.
the question therefore arises is as to whether the land in question
Yes.
belongs to you or the respondent number 7.
Yes, me, confirm.
Absolutely. No, that is the question.
Yes.
Now that is pending before the civil court.
Yes.
Why should this court entertain?
No, that part, Lordship, that is true, Lordship.
Hmm.
That Lordship cannot entertain, Lordship. That I agree. But here, Lordship, my part is not for that part of land. My grievances is only with the PNRD government, state government, that why they have entered into our dispute by sanctioning that amount and then by misleading the page number 16, Lordship. And
No, let us assume that they have sanctioned.
yes.
How does it make a difference
Look-
if they can't construct?
No, they are constant. No, they can only stay. We have given in representation also to them, Lordship. Let them dispose of the representation.
Mr. Sharma, this court doesn't go into the question
No, no,
of disposing of.
Lordship, in that case, Lordship, I pray, Lordship, one part, Lordship. Why cannot, Lordship, may I pray, Lordship? Lordship, here, I am not going to the dispute of the land property. I'm not placing the.
No, your entire gamut of the dispute is this, that your land is 2 bighas of land.
Yes.
And the respondent number 7 has been allotted a particular sanction, a particular amount.
Yes.
For construction of a building or a house in your land. Now,
Yes.
the dispute that you are the owner of the land is pending before the civil court.
Lordship.
Now, who is going to decide that the land belongs to you or the respondent number 7? The civil court. So, are you not? Is it your business out there for moving an application if he's constructing?
Yes, I agree to it.
And once you stop him from constructing out there, if you stop him, the money, if he's wearing, he can't utilize it.
Yes.
Matter ends there.
Yes, that.
Then why should this court entertain such dispute?
Lordship, here the dispute is not private.
I understand. You are saying that why the PNRD had given the money.
Yes.
Sanction.
Yes.
Yes, whatever may be.
Hmm.
If the PNRD gives him the money for doing something, how are you bothered? Your bother should be only that he should not construct in your place. That's it. That is your quarrel.
Lordship, here that part I can again raise to that Lordship, Lordship, by going to the civil court, Lordship knows very well, Lordship. Yes, I won't go to that aspect, Lordship. Here my query is that reference number 7, while in the counterclaim, has already admitted that land does not belong to him. He's claiming counterclaiming by adverse possession.
So what do you want? You want the PMDAY amount to be paid to you?
No, I want that people.
Why are you concerned?
I want that they should. If
I
want that, Lordship,
Mr. Sharma, I can give you one good opportunity for moving to this. I can dismiss this on the ground that this is a dispute between you and the respondent number 7 for which the civil court can decide.
Yes.
You can go by that way to the appeal in court number 2.
Right.
Or you're seeing your grievances. You can otherwise also go to the court number 2 by way of FPI. Whichever you. But you go to court number
2. I have to. Lordship, here my part is there, Lordship.
Don't spoil your case by getting a dismissal here. Don't spoil your. You go and move an application out there, get it stayed. Or do whatever may be that he cannot construct. Once he can't construct out there, then the money, if it is paid, also becomes useless. He cannot, if he is not doing anything, he can't give the utilization certificate for which he would not get any amount. Kindly see his sanction letter. It makes it clear that he will be only paid subject to utilization. Then, on receipt of information regarding the site of work where the dwelling unit has been constructed, fund can be released in installment. That means what? If he can't construct there, the question of releasing the fund on installment doesn't arise.
That part I agree, Lordship. Lordship, can there be a
Therefore, I'm saying, are you agree that the amount, I would have understood that the amount the respondent number 7 should not have got, it should have got.
No, I do not require, Lord.
Then
I do not require money, Lordship. I am
Why, what do you want? Dismissal?
No, Lordship.
Or withdrawal?
Lordship, I want.
Or file a PI?
Okay, Lordship can record it. I may be allowed to go for a PI. Liberty to file a PI.
I don't want to give you the look. Yes.
Lordship, can it be, Lordship? Here, my 2 minutes, Lordship. My grievances is that no, Lordship, the respondent number 7 in the title suit has categorically admitted.
No, tell me, if the respondent number 7 grants a sanction of certain amount for construction of a building, does the right over the land is created upon the respondent number 7? If the state, if the PNRD grants any amount, a right is created upon the respondent number 7 over the land? No. Then,
no, Lordship can, but he has misled. Okay, Lordship, my prayer is that this representation may be disposed of. Representation should be disposed of.
Absolutely. That is for you. Why should I go for that representation? Yes, I would have understood. Your representation, they may not stop it. How does it matter? You can get it stopped out there from the injunction by getting an injunction not to construct.
There is there.
There, you
There
have
is
already
there.
have a status quo order.
The status quo order is there.
We know that the dismissal will have a far-reaching consequences in the civil.
Okay. With the liberty to appropriate court order.
You already have approached the appropriate.
In that way,
The learned counsel, the pitch heard Mr. Sharma, the learned counsel appearing on behalf of
Manjushri Haloi, Nili Agarwal, Deepak Gupta.
the submission of the learned counsel for the petition. That that although there is a civil suit pending where there is an injunction order on the basis of amount on the basis of a sanction so granted by the respondent authority, the respondent number 7 is raising construction. He, however, submits that there is a status quo order passed by the learned trial court. It is the opinion of this court that it would be that the petitioner would be well advised to approach the trial court for appropriate orders if deemed fit, if so advised. This court, taking into account the facts, is not therefore entertaining the instant petition. However, leave is done. However, the non-entertaining the instant petition and the consequential dismissal of the petition shall not prejudice the petitioner in the proceeding before the trial court, as well as also to file appropriate.
deeply obliged, Lord.
Some personal appearance.
Item 27 through BC.
We filed an affidavit this morning, my lord, getting it on record, my lord, and I've sent the video call link to the officer concerned.
We can have it at 11.
My lord, my lord.
Yeah.
Obliged.
Now, tell me one thing. In your affidavit, what have you mentioned out here?
Well, we stated that there are many claimants to the plot of land on which they claim a rent, and they have to establish their title. We'll make the payment available. My lord, everybody is claiming. My lord, 2 or 3 persons have already applied. Everybody,
No. Question before the court, which the court has put, is whether you were in occupation of particular land or the building from 1/2/2010 to 31/8/2015. That was the specific query. And if occupied, whether monthly rent already assessed has been paid to the petition. That is the question.
rent has been assessed, but they could not pay because there are 3 or 4 persons who have come and claimed the money.
You have mentioned who are the 3 or 4 persons?
Neeli Agarwala, Assam Tribal Sangha. Lordship may have a copy.
We do one thing. In view of this affidavit, we dispense with the personal appearance. and
Clear.
you file your affidavit. Because here what they have mentioned out here, that yes, they have assessed, but the fact that there are many claimants out there. So under such, I think it would be better on your part to file and reply. You have got a copy of it?
No, okay.
Well,
Okay,
office,
give him the copy of it.
yes, well, the office formally.
This court by an order dated 3/1/2024 sought for instruction from the Deputy Commissioner Kamrup Metro as to whether the respondent authorities have occupied the landed property of the petitioner for the period from 1/2/2010 to 31/8/2015, and is occupied whether the monthly rent already assessed have been paid to the petitioner for the said period. This court had also, by the said order, sought for the personal appearance of the Deputy Commissioner Kamrup Metro to the video link. It is also seen that Ms. S. Sharma appearing on behalf of the respondent, appearing on behalf of the Deputy Commissioner Kamrup Metro, had submitted that an affidavit has been duly filed to the effect that that there is no denial to the fact that there has been an occupation of the land in question. Is a land or building?
It's a land along with the Contempt house.
In respect to the property in question, with effect from 1/2/2010 to 31/8/2015. However, on account of the fact that there has been various claimants, the amount could not be disbursed. So taking into account the above, this court is of the opinion that a reply from the petition would be required for a proper adjudication of the instant petition. So therefore, 2 weeks' time is granted to the petitioner for filing the reply. 3 weeks' time is done. This is the matter again on 19th of February 2024. There was the personal appearance of the Deputy Commissioner Kamrup Metro in view of the filing of the through video link, in view of the filing of the affidavit and the instructions being placed is dispensed with.
Deeply applied.
And number 3. Yes, what has happened?
Sir, I have got the instruction, sir. Well, in fact, Lordship will see, Lord, the Honorable Court order was passed on 24/7/2023, and by 11/2023, 9 crore rupees has been given. 9 crore rupees has been given to the State Legal Service Authority by the government, and out of that 9 crore, the 5 lakh rupees is to be given to the petitioner. They could have very well utilized that account. Now,
So you have already paid, you have already disbursed, so
We
your
already-
duty is over.
Yes, now they have on 22nd of December, they have given us a letter that the amount which we have given 9 crore, it is already exhausted. So you give us additional fund. The budgetary allocation for 22-23 is 9 crore. Entire amount has been given to them. Can you see the second page, the second letter? So the respondent number 2 here, he can clarify why out of 9 crore rupees, 5 lakh rupees has not been given to the petitioner.
Was there any direction upon the other authorities?
Well, yes, kindly see the order, Honorable Court order, para 2.
Because,
Para. The Learned Council appearing on behalf of the respondent number 3 has submitted that on account of non-release of funds by the state government.
where there is a violation being committed by the respondent number 3, the Assam State Legal Service.
Respondent number 2, now in the contempt petition, there are 2.
He has definitely violated it.
Well, the notice has to go to the respondent number 2, but the respondent number 1 and 3, they have done their part.
But where will he pay from?
But now the instruction can you see that the present budget, whatever the allotted amount for the financial year 22, 23, 24, malad, the new budget will come, malad, new amount they can release at that point of time.
You notice.
Sure.
I'll issue notice to one also.
At least, malad, the respondent number two, let him
Who has to be done?
let him explain, malad, why.
Let him explain this because there was a specific direction upon respondent number 3
Correct.
in the petition.
Correct.
And here, in view of this instruction of here,
Lodge.
the amount was of 9 crores was duly released, and they should have therefore taken the payment of that.
Yes.
When there was an order passed by the court.
And Lordship has passed the order in the month of July. The amount has been given to them in the month of November.
November.
They
Yeah.
could have very well given. And the amount is 9 crore. How they have utilized, let them see.
Could not have done that. But if I don't issue notice to one,
I'll bring this on record by filing.
no,
affidavit.
understood. If I don't issue notice to one, it will be very difficult to comply later. Because overall, whatever it be, the amount has to be given by them. I think the best option will be you should take action against the Assam State Legal Authority because they have misutilized the fund. Issue notice. And what about number 3? He has no business.
He has no business.
3 we strike. Issue notice to the respondent number 1 and 2.
In fact, one thing just I'd like to point out. In fact, I have seen in the bunch, Lordship will find the letter of the petitioner is 18/12/2023. He has given an application to the district judge
Yes, Lordship.
for seeking the amount.
Yes, Lord. Remaining the
And thereafter on 20th of December, the district judge has written to the State Legal Service Authority. On 22nd December, State Legal Service Authority has written to the government. The order was passed on 24/7.
Why did you give it so late? Why?
No, it is the
No, no,
petitioner's letter.
Huh?
Petitioner's letter.
No, no.
Petitioner has given the letter.
Why did you
This is
give the
there.
letter on 18/12?
18/12.
15 on 15, 12. 15, 12.
Why did you give it the letter so late?
No, there is no date, Lordship.
Huh?
There is no.
There is a date.
Lordship, that's because Lordship, on 15, 12.
18/12, page 13.
Page 13.
I'm saying Lordship. Page, Lordship on 12, page number 12, Lordship. When this amount has been received, Lordship, then Lordship, the remaining.
This is a reminder that the remaining
Yes,
5
Lord.
lakhs.
Yes, Lord.
5 lakhs, Lordship, when the order was passed. At
But
that
in
point
the-
of time, Lordship has noted that 5 lakhs already received. But the remaining 5 lakh only.
But the direction was given to you and the council who was appearing for the Assam
Respondent
State
number
Legal
3.
Service.
Yes,
Correct.
You
But-
see, kindly come here,
Yes,
paragraph 6.
let us see.
The registry is directed to serve a copy of the instant order to Mr. D. Nath, the learned here. Because here it has been mentioned that the amount would be disbursed by you
Yes.
because it is already sanctioned.
Correct.
Then they have made this mistake out there.
Yes. Now the 5 lakhs rupees, Lord, that was already received. That earlier he has
No,
been
no,
given.
not that. Not that.
No, 5 lakhs was given on 15/12. Therefore, he wrote another letter on 18/12 that I am actually entitled to 10 lakhs, but you have paid me only 5 lakhs.
They could have by that time the fund is there. 9 crore entire fund is given to them in the month of
No,
November.
that I understand.
Look.
Issue notice issue notice upon the respond number 1 and 2. The petitioner would take steps upon the said respondent by way of registered as well as usual. This court is not inclined to issue notice upon the respondent number 3, as this court finds no reason to do so, more particularly when there was no direction in the order dated 24/7/2023 upon the Commissioner and Secretary to the Government of Assam Finance Department. Full stop. This court have full stop. When the matter was listed on 10/1/2014, this court had taken the opportunity of inquiring with Mr. D. Nath, the learned counsel who represented the respondent number, who represented the home department, home department of the government of Assam during the writ proceeding to verify, to obtain instructions as to why the amount of 10 lakhs, which was directed to be paid, have not been paid. Today, when the matter has been listed, Mr. Dina, the learned counsel, submitted that an amount of rupees 9 crore was duly released to the Assam State Legal Services Authority on 14/11/2023. Out of the said amount, taking into account the specific directions passed by this court, the said amount, the amount of rupees 10 lakhs ought to have been paid to the petitioner. However, it was the mistake committed by the Assam State Legal Services Authority of making payment of rupees 5 lakhs and not rupees 10 lakhs. This court have also taken note of another communication which have been issued by the Assam State Legal Authority on 22/12/2023 to the Commissioner and Secretary to the Government of Assam Home and Political Department, wherein it has been mentioned that the amount of rupees 9 crores which was sanctioned and disbursed have been fully utilized. And as such, there was no amount to be paid to the petitioner. This court finds it very pertinent to mention that when the matter was taken over, when the writ proceedings was taken over, it was categorically mentioned that the amount of rupees 10 lakhs, the petitioner would be paid. And under such circumstances, there was a specific direction upon both the Home and Political Department of the Government of Assam, as well as the Assam State Legal Services Authority, to disburse the said amount to the petitioner. This court had also directed the registry to serve copies upon the councils representing the Home and Political Department, as well as the Assam State Legal Services Authority, to ensure that the order passed by this court was duly complied with. It is, however, not understandable as to why, in spite of the said order being passed, the Assam State Legal Services Authority had not disbursed the amount, the entire amount of rupees 10 lakhs. More so, when the order was passed on 24/7/2023 and the amount of rupees 9 crores was received on 14/11/2023. The respondent number 2 shall file an affidavit explaining as to why the amount was not released, the entire amount was not released to the petitioner in spite of the specific directions passed by this court. Issue notice making it returnable on 6th. When is the budget?
Budget will be the session will be, date has not been announced. Probably in the month of March.
No.
February.
Now this budget is earlier.
February, February
February first week or something like that. We'll have it on 19th of February.
19th.
19th of February 2024. Issue note.
Highly applies.
The materials, and I think you keep it. You may file the affidavit.
Yes,
So this is required.
Highly applies.
You can give a photocopy of this. I can keep it out.
photocopy of the photocopy set I have.
The documents which have been placed by Mr. Dina during the course of the hearing is kept on record and marked the letter X.
Look, here the sealing copies are not there, but all 4 letters are available.
Give whatever it is. You
Lot
for these, I think that the letter is there, na, some state.
letters.
Yes.
All,
these are
all 4 letters. Only the sealing copies. No?
are collectively kept on record.
I'm okay.
Yes.
Let order of this honorable court is at page 7 and relevant is at page 10.
They have not done it.
My lord, nothing was
Notice taking it returnable on 9th of February 2024. The petitioner is directed to take steps upon the respondent by way of registered as well as usual. Further to that, you have one liberty, trustee.
my lord.
The petitioner further is given the liberty to take steps by way of trustee upon the respondent, routed to the registry of this court and file an affidavit of service on or before the next stage. Yes.
May I plead with-
Hmm.
But what happened? I lost an FIR before the OC, Jalpuri PS on 22/8/2020 to page 27. My lord, the case was registered and investigated, my lord. The culprit, the fact of the case is that my one Devojit Bhattacharya, who took out my vehicle on rent 40,000 per month. And my lord, he has sold out the vehicle. Now, my lord, vehicle was I am not getting. I got information it was taken to the Manipur and the number plate was changed. And it has been taken to Dimapur diesel engine company of the Tata, where my lord, they have informed me, your vehicle is here. But I have approached the police office authority to bring the vehicle here. They are not doing anything.
Where is Pranjal Sharma?
Panchayat Sharma, they are absconding, all these people.
Now, how are you going to get a relief out here?
But the police is not arresting them. They said that we don't get them. Anyway, but my vehicle has been recovered at the Tata
Now,
Diesel.
has the vehicle been recovered?
It is there in the Tata Diesel at Dimapur. They are informed me that it is your vehicle.
Understood, but has it been recovered?
No, it is. I got the information. It is there. I have
Till now.
informed the police. So you go and bring it first. Then not encouraging.
Which police station?
Jalukbari man.
Let's not issue notice upon response number 6. We are only concerned about the recovery of the
Exactly,
vehicle.
exactly.
Because the moment we
So, I
issue
mean, the
upon
another
6,
topic that
your
they have-
petition would
They
not.
registered the case at 420. If there is 420,
No,
I'll not get
no, no.
interest
If they
rate.
invest, I'm not on the question of investigation.
Yes.
Investigation not done, you can very well go under 156(3).
Yes, but
I'm only concerned about the vehicle.
kindly.
So I think an order passed by the High Court would be more effective on this than a 156(3). But as regards the investigation not being done, you move under that. Issue notice, making it returnable on 24th of January 2024. Mrs. Yudas, the learned additional senior government advocate, appears and appears on behalf of the respondent number 1 to 5 and accepts notice. Extra copies of the writ petition be served upon the upon Mrs. Yudas, the learned additional senior government advocate, during the course of the day. This court is not inclined to issue notice upon the respondent number 6. This court also is aware of the fact that a proceeding, if there is any, is aware of the well settled principles of law that if an investigation has not been carried out in the proper fashion, in the proper manner, the petitioner duly has a right to do so, to apply under section 156(3) of the Code of Criminal Procedure 1973. The petitioner can very well. However, this court has taken up the instant writ petition only for the purpose of passing appropriate directions upon the respondent authorities for the purpose for giving an update as regards the status of the vehicle, which the petitioner have duly informed that the same is lying
The Tata Diesel,
in the Tata,
Diesel. It is workshop of Tata
where?
at Dimapur, my lord.
Tata Diesel.
Yes.
What is this
They
diesel?
have sent me information, my lord. I take you lot to my lord, page 39, you lot will find
Tata Diesel where?
at Dimapur, my lord.
Page?
Dimapur,
Page,
page 39.
at
Tata Diesel, Dimapur. Contact workshop number such and such. For
Tata
taking
Diesel.
delivery,
No, that is
you
not
may
Tata.
click it.
Customer care application, motors, pickup, and so Dimapur Diesel,
Yes.
not Tata Diesel. Dimapur
Dimapur
Diesel.
Diesel. It is meant, it is a Tata, owned by Tata.
Understood, but its name is Dimapur Diesel. Is lying at Dimapur Diesels, which is located at Dimapur. The officer in charge of Jalukbari police station shall give an update, status update, as to what actions have been taken in pursuance to the information so furnished by the petitioner in respect to the vehicle lying in Dimapur Diesel, Dimapur. It is, however, made clear that the pendency of the instant writ petition shall not bar the petitioner to approach the competent court under section 156(3) if the petitioner is agreed with the investigation so carried out.
Diploma.
Madam, you just instructed.
Here, your lordship, we have put to challenge certain notices, eviction notices issued by your lordship, the range officer, your lordship, forest, your lordship. Kualia,
So your case is that it falls in the village.
Lord.
Their case is that it falls in the forest.
Sure.
So why don't I dispose of the writ petition directing the forest officials as well as the circle officer to carry out the necessary demarcations, and if it is found, then to carry ahead
Lord.
with the investigation.
Lord,
I think that is a
Lord,
win-win for both of you.
Yes,
What am I going to do?
Lord.
Instant writ petition is taken up for disposal at the stage of motion itself, taking into account the facts involved. The fact of the instant case, as would be discernible from a perusal of the writ petition, is that the petitioners herein claim that they are residents of village Madhurbon, P.O. Hurunga under police station Patharkandi in the district of Karimganj. It is the specific case of the petitioner that they have not encroached upon the reserve forest reserve forest na,
Reserve forest, Rohalia.
Rohalia.
upon the Dhulia protected forest and have also not constructed any house, upon as alleged in various notices which have been issued. The grievances of the petitioner is that the forest officials, without taking into consideration that the petitioners are actually residing in the village, which is not, in the village,
Revenue.
in the revenue village land, in the revenue village land at Madhurban, have issued the various notices to the petitioners that they have entered into the Dhulia protected forest and constructed houses, ponds, and converted the forest land into agricultural land, for which the instant writ petition has been filed. This court have also heard Mr. Aibo Thakur, the learned counsel, appearing on behalf of the Forest Department, who supports the impugned notices which have been issued on the ground that the petitioners are in occupation of the Dhulia forest, protected forest area, are in illegal occupation of the Dhulia protected forest. The dispute which have been raised inter se between the petitioners and the respondent cannot be decided in the instant proceedings as to whether the petitioners are in occupation, of revenue village land or have encroached upon the Dhulia protected forest. This issue, however, can be resolved by issuing appropriate directions by this court. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, when? Madam, Circle Officer? Which Circle Officer? Karimganj? Huh? Circle Officer is Pathakar. You are paying for it. When do you want to make the verification?
30 days.
30?
Yes.
This court directs the Circle Officer Patharkandi, Revenue Circle, Patharkandi, who is the respondent number 4 in the instant proceeding, as well as the Range Officer Dhulia Sargola, who is the respondent number 9 in the instant writ proceeding, to carry out the verification as to whether the petitioner are in possession of land within the village, Madhurban, or have encroached in the Dhulia protected forest area on the basis of the available maps and on-site inspection, on-site verification, on-site visits. The said verification shall be conducted on-site on 30/1/2024 at 11 a.m. The petitioner the said officials shall permit the petitioners to be present on present during while carrying out the said on-site verification. Depending upon the said outcome of the verification, the respondent authorities shall carry out further steps, they shall take appropriate steps in accordance with law. Next, number 2. This court further directs that till the verification is concluded, the possession of the petitioners in respect as they stand presently shall be maintained, shall not be disturbed, shall not be as they stand today, shall not be disturbed.
Your Lordship, so far as that petitioner presence is concerned, it would be better if representative of the petitioner, because there will be huge number.
এটা এনেকে লাইন লিখি দিবা তাৰ আগতে আইব ঠাকুৰ সেইটো কৰো না representative of the petition, maybe, in presence of the Seven. Yes.
Yes, my lord, my lord.
Hmm.
Here the petitioners are 9 members of the my lord, Ilapatha Municipal Board, my lord, elected members directly. Having dissatisfied with the chairperson, my lord, they gave a notice of no confidence, my lord, under section 28 of the Assam Municipal Act 1956 on 1/12/2023. Then there was no action taken. Then again, they reminded the Deputy Commissioner 7/12/2023 for holding the allowing the no confidence motion to go. The decision.
Mr. Sharma, was any other petition filed earlier?
No,
In
no.
2-3
This is the
days?
first
No, na?
No. No, what? Because the last cause of action is valid here. 5/1/6/1/2024.
Now, was there any challenge that without following the due process and no confidence motion has been initiated against the chairman? Nothing like
No,
that.
no. This is the different issue, my lord. Here, whatever, my lord, DC allowed ultimately on 4/1/2024,
Hmm.
DC allowed and giving us the direction to hold the meeting on 5/1/2024. On 5/1/2024, meeting was called. Meeting was held in process, my lord. Immediately, police, one SI and 2 constables came in, picked up the vice chairman, chairperson itself, who was presiding over the meeting, and 2 other persons were also kidnapped by some goons, possibly engaged by the chairperson. So meeting was disturbed, they could not hold. Then immediately FIR was filed, my lord, 1 to the OC, and that to the SP, my lord. Then again to the DC. Same day on 6th. No action step. What we want, my lord, the no confidence motion should go with a bit of protection or safeguard to during the course of the meeting, so that the all can attend.
No confidence motion to against whom?
Against the chairperson.
So many people are there.
Yes.
Okay, I think the only case is we have to issue notice.
No, your lord, to me, issue notice fixing a bit urgency is there, my lord, because the
But you have to serve because there are other persons out there. That is why there are a lot of private respondents. Huh?
will serve. Dusty will serve.
Yes, okay. Issue notice making it returnable on 29th of January.
That will be that.
No.
20.
Before not possible. 29th of January. No heavens will fall. 29th of January
Because the fund is being
2024.
diverted by the chairperson unilaterally.
Hmm?
The chairperson, 20 crores is sanctioned by the government. 6 crores he has diverted somewhere.
Very well. That is another investigation to be carried out. Notice making it returnable on 29/1/2024. Full stop. Madam, you are appearing for 1, 2, 3,
3, 4, 5.
4, and 5. Mrs. Yudas appears on behalf of the respondent numbers 1, 2, 3, 4, and 5 and accepts notice. Extra copies be served upon her during the course of the day. As regards the respondent number 6 to 10, the petitioner is directed to take steps by way of registered with AD by by tomorrow or by during the course of the day.
Yes.
During the course of the day. Further to that, the petitioner is also given the liberty to take steps by way of dusty upon the said private respondents numbers, said respondent number 6 to 10, routed to the registry of the court and file an affidavit of service on or before the returnable date. The petitioners herein are aggrieved by the respondent by the inaction on the part of the respondent by the actions on the part of the respondent authorities in not permitting the petitioners to go ahead with the no objection, no confidence motion against the chairman of the respondent number 6. So various serious allegations have been made against the said private respondents. Serious allegations have been made in the petition against the official respondents as well as the private respondents. Taking into account the above, this court, therefore, it is the opinion of this court that without hearing the respondents' version, passing any interim order at this stage would not be in the interest of justice. Under such circumstances, this court shall further consider the interim pair on the returnable date.
Then normally if they appear, they give a lot of protocol.
Provided it comes to me.
It will come to your lord. Hello, one thing. Respondent 7, married. I guess respondent 7.
What?
Respondent 7. The motion is against respondent 7. Not 6. Your lordship passed the order on 6, married. It is against 7. Lavanya.
No, you are making allegations against everybody.
Everybody, but the motion is against her.
Understood. I am not on that. The no confidence motion they are not permitting. Huh?
They are creating lawyers
Against the phone number 7. Huh? Against the chairman. I take chairman.
Can I pray one more? In the meantime, the chairperson immediately set up transfer any fund because you are the board.
Absolutely no. Without hearing, I said now, without hearing the other side, it is not proper to do.
At least for some instruction.
You take step. You have my order?
Yes.
Similar order?
Yes. Well, I have NF.
Ito photo আছে
Coordinate bench order page number 38.
You have, Mr. What are you have my order?
I don't have it now, right now. Not even last week has passed an order.
38.
Yeah, order. Yeah.
38 and 43. 245.
I think this matter needs to be earlier heard and finished off. Unnecessarily, so many matters are coming.
Every day one.
When are those other matters picked? I have picked some matters someday. And what is the case of the petitioners? Who are you?
Yes, my private, my lord, my construction is my residential purpose. G+2 building, I am going to my lord construction for personal.
Personally?
Yes.
এই আপনি এইটো চাওক মেডি চাওক order এইটো
Page
working ঠিক
43
আছে কাটটো ঠিক second paragraph to second paragraph petitioner herein owns a plot of land and intends to construct a residential building for which permission have been sought from the Guwahati Municipal Corporation. However, on the basis of the notification dated 2/3/2023 of the Mines and Minerals Department of the Government of Assam, the petitioner has been asked to pay 2%, 2%, no?
2%.
2% of the 2% of the project cost prior to as a condition precedent for issuance of the permission. It is the case where the applicable to the original page 45 issue notice returnable on. Yes, when do you want this matter to be
If we check with the requisition number 2040 of
on?
2020.
They did
No,
not.
No, I'll be
Lottery will fix it after reopening.
reopening is too early.
Last week of February.
When you have you filed any affidavit?
No, here the government have to file. If the Mines and Mineral Department has filed, put the letter.
Understood, but why you are doing then if you are saying that the government is to file? They are only challenging your actions.
But
If you don't file, that is
your
your mines and minerals.
My lord, the government, my lord,
Then why when are you filing your affidavit?
lordship.
one affidavit.
High court. My lord, 3 weeks time may be granted. For 4 and 5 months.
एकदम ऊपर लिखी हुआ है, to notice making it returnable on 23rd of February 2024. Mr. R.R. Gogoi appears on behalf of the respondent number 1.
I pay for 2.
1 and whom?
1.
1. Mrs. U. Das, the learned additional senior government advocate, appears for the respondent number
4 and 5.
4 and 5.
2, 3,
Mr. G. Espora appears on behalf of the respondent number 2,
3 and
5 and 6.
2, 3 and 6.
2, 3 and 6. As the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. তাৰপিছতো মই যোনটো paragraph ক'লো তাৰপিছৰ পৰা এই কথাটা ইছ্যু নটিচটো পঠাই দিব আৰু এইটো ই গগৈ সলনি R.R. গগৈ কৰি দিব আৰু পেণ্ডিং কাউন্সিল এয়া টি নায়কৰ সলনি এছ বৰা ইউ দাস এইবোৰ নালাগে এইটো জি গগৈ নালাগে এই paragraphটো নটিচটো পাই extra copies যোনটো কৈছো এইখিনি the criteria but are the learning boundary there considering the constraints of the activity paragraph page 46.
This along with requisition number 2040.
This is the matter along with
requisition number 2040 2020.
The respondents are directed to file their affidavits by 12th of February 2024. The petitioner herein would be at liberty to file the reply, if any, reply on or before 21st of February 2024.
Third week of February.
Third week of what? That is what I've asked you. I've asked you to file it. Okay, on 16. 16, file the affidavit on 16. I mean, I picked it on 23rd.
23rd, lordship.
You file your affidavit by 2016.
16.
Yes,
Lord.
at least the matter.
May please, Lord. This is application under Article 226.
Yes, what is it?
Page number 52, Annex 5.
Hmm. So they are not making inquiry. Yes, why? Why you are allowing our respondent number 5 to make doing nothing? Issue notice making it returnable by 12th of February, 19th of February 2024. Mr. Ardhor appears on behalf of
One,
the
two,
respondent
and
number
four.
1, 2,
Four,
1, 2, 4, 1, 2, and 4.
My friend is appearing for
Mr. Ms. M. Borman appears on behalf of the respondent number 3. As the respondent numbers 1 to 4 are duly represented, extra copies of the petition be served upon them during the course of the day. As regards the respondent number 5, the petitioner is directed to take steps by way of registered as well as usual by 18th of January 2024. Full stop. The case of the petitioner herein is that the petitioner that the petitioner is aggrieved by the inaction on the part of the respondent authorities in not taking steps against the respondent number 5, in spite of the fact that the respondent number 5 have not been carrying out the periodic renewal of Uzirar Sor to Mohua Road under Mukhya Mantri Pradhan Nobikoron Pasoni for the year 2022-23. Isn't it? The respondent number 1 to 4, 1, 2, and 4 shall apprise this court as to what steps have been taken against the representation and shall apprise this court as to whether the respondent number 5 have been taking appropriate steps in respect to the contract which have been allotted to the respondent number 5.
I will try to get an inquiry report if required, so my lord. I will let them make an inquiry, these officers.
No, you
File
just apprise this. I'm not asking you to file it.
Yeah, please. Lord, in this case, my lord, because my lord is a public sector undertaking. What happens is, my lord, they received a contract from BSN. It was given on back-to-back basis to another company, my lord, to actually undertake the contract. My lord knows that under GST on every stage, my lord, tax is to be paid, though the actual work is being done by that subcontractor. Now, my lord, what happens is that there was some delay on part of this PSU to file its return. The contractor has already paid the tax. That, my lord, he bills to me, which I claim as input tax credit. I raise invoices on BSC. So, my lord, on one stage, contractor has paid the tax. Now, the department has issued this show cause notice saying, and the order has been passed saying, that since I filed the returns late, therefore, my entire input tax credit would be denied, and the tax that already stands paid to the credit of the government, I will have to pay it again. My lord, that is the implication. This honorable court, my lord, is already examining this matter, and my lord, notices have already been issued. That is one part. Now, my lord, what happens in this case is, my lord, the Supreme Court has said in the case of Bharti Airtel Limited that credit is to be availed in the book. That is the primary source. It is also shown on the portal. That is a duplication, and it is only a matter of recording it. But, my lord, actually the credit is taken in the book. That is one part of it. The second part of it is, my lord, that what happened, my lord, that initially they issued a trinity of forms. 3 forms were to be filed, my lord, GSTR 1, 2, and 3. The main return was in form GSTR 3. My lord, their portal never introduced it. They were not able to introduce that. It is admitted. GST Council minutes recorded twice that there is a delay on our part, and therefore we are extending the time limit. 5 notifications, my lord, were issued saying that extended date shall be notified separately. My lord, if at all I had to, if their contention is to be considered as correct, then I had to file that return and I had to claim credit in that return, which according to them, they had to extend the time limit. My lord. Now, my lord, they did not do it. On one fine morning, those notifications are there, my lord. They are not resigned it. They are still there saying extended date shall be notified.
Now, my lord, one fine morning, what they do, they amend the rule retrospectively, a separate rule retrospectively, saying that the return which was required to be filed is now not in GSTR 3 form. It is in a form which was separately a stopgap arrangement, my lord, was introduced in a form called GSTR 3B. Lord, they say now in place of GSTR 3, GSTR 3B will become the return. So, my lord, now,
When did they say that?
my lord, that is said by notification 49 in 2019, October 2019. They said so.
Show me that.
Yes, sir. My lord, would be 49, my lord, would be annexure Q.
Page.
Yes. My lord, this is page 302.
30?
302, my lord. My lord, please notification 49, it says, my lord, these rules may be called as so and so amendment rules, save as otherwise provided, they shall come into force on the date of their publication. Now, my lord, would kindly see 3.
Where is the date? They were otherwise provided in a date that, I mean,
On the date of their publication. But
when
my
was
lord
it
would see
be
3.
published? No, when was it published?
My lord, is for 3, which is the relevant amendment in this case, my lord. They said that it shall be from the first date itself. My lord, would kindly have 4 at the bottom of this page, my lord, in the said rules, in rule 61, my lord, the last line. This is the relevant rule, my lord. On the next page, my lord, would
Wait,
see.
wait. Are you in a hurry, Mr.
No, no, sir, I'm sorry.
Close. I have a lot of them.
Yes,
You are referring to clause 3,
clause 4, my lord.
clause 4?
Yes, ma'am. On the same page, 302, last line it starts.
That is clause 4.
In the
You
said
are
rule.
referring to clause 3 of this notification in the said rules in rule 36
I'm sorry, my lord.
after sub
I'm not
rule
on
3.
My lord, just below that 4. I'm
Understood.
referring to 4.
Until I understand that you are referring to the insertion of rule,
No, my
sub
lord,
rule
I'm
4.
not. I'm sorry, my lord. No, I made a mistake, my lord. I am referring to para 4 of this notification, which is just below that on the same page, my lord. It starts below that.
4 is where?
My lord, it says, my lord, it would start like this. In the said rules, in rule 61. That is what would appear on 302. For sub rule 5, the following sub rule shall be substituted
In the
with
state
effect
rules,
from 1st
in
July
rule
2017.
61, in rule 61A,
That's right, my lord.
for sub rule 5, the
5.
following shall be with effect from 1st of July
1st of July
2017.
That's right. And what the amendment was, my lord, the substitution was like this. Here the time limit for furnishing of details in form GSTR 1 under section 37 or in form GSTR 2 under section 38 has been extended. The returns specified in subsection 1 of section 39 shall, in such manner and subject to such conditions as the Commissioner may notification specify, be furnished in form GSTR 3B electronically through the common portal, either directly or through a facilitation center notified by Commissioner, provided that where a return in form GSTR 3B is required to be furnished for a person referred to in sub-rule 1, then such person shall not be required to furnish the return in form GSTR 3. So, my lord, earlier I was required to file GSTR 3, for which they kept on saying we will extend the date. From this date, my lord, retrospectively they stated that wherever there is delay on our part in notifying GSTR 1 and GSTR 2 or in providing the dates, instead of GSTR 3, you will be required to only file 3B and no 3 will be filed.
So it says that, but it doesn't specify when.
My lord, for the
Where the time, you finally see where the time limit for furnishing of the details in DSTR 1
Yes,
under
Lord.
so and so, DSTR 2 under review has been extended.
That's right.
The return specified under subsection shall in such manner
Yes, Lord.
and subject to such condition as the Commissioner may, by notification, specify, be furnished informed so and so electronically. So there has to be a notification.
That's right, my lord. So 3B notification was there. There is no dispute that they kept on issuing, my lord, because never they were able to come out with DSTR 3. And ultimately, therefore, my lord,
Understood. Where is the notification?
yes, my lord, that extension notifications, my lord, would find at annexure O.
Page.
Yes, my lord. My lord, this is page 287. My lord,
Now,
they were
when was this rules, this amendment at page 302, annexure 2, annexure Q?
Q, my lord. Yes, my lord.
When was it published in the
My
Gazette?
lord, 9 October 2019. That is on the top of the page.
No,
right
no,
side.
on top of the page, it says to be published in the Gazette of India Extra. Has it been published?
Yes, my lord. Yes.
When?
My lord, would kindly see at the last on page number 306, it is mentioned, my lord, that the principal rules were published in so and so, published by
Page?
my lord, page 306.
Principal rules were published in the Gazette.
No, my lord. In fact, this is only referring to the previous rules, my
No,
lord.
no.
This is not
Whether
referring.
these rules have been published.
My lord, these have been published, my lord.
When?
Probably I have.
Now,
not-
why I'm saying is,
Yes, my lord.
because 1-2 says,
Yes, my lord.
wherever otherwise provided, these
Yes.
rules shall come into force on the date of a publication in the official Gazette.
So far as I may not recall, this is the date of 9th October itself. They have been published on the same date, but I'll confirm this. I'll note this.
Okay, then
But they have been.
thereafter this notification is been issued and annexure O.
Yes, my lord. Oh, my lords would see. From time to time, they kept issuing notification extending the time limits which my lords were observing. My lords would see this is 29 December, my lord. 287, my lords are there.
No. What is this notification after as per 5, the newly amended 5 rule? Here it says, in such manner and subject to such condition as the commissioner may by notification specify be furnished in so and so electronic to the year. Where is that particular thing?
My lord, what
is
happened
this in
was.
continuity of this?
Yes, my lord. My lord, one moment, if my lord would just see this rule once again, my lord. I read rule, my lord, are on page 303.
Page 303.
Yes, my lord. I just start with where the time limit for furnishing of details in GSTR 1 under section 37 or in form GSTR 2 under 38 has been extended. So, my lord, this is the precondition. So, my lord, that precondition, my lord, the notification is at annexure O. My lord, would kindly see page 287. Lord, it says in exercise of powers conferred by second proviso to 37(1), read with section 168, and in supersession of notification number 58, dated so and so, except in as respect things done or omitted to be done before such supersession, the commissioner, on the recommendation of the council, hereby extends the time limit for furnishing details of outward supply in form GSTR 1 under subsection 1 of section 37 of the Act for the months as specified in column 2 of table below. So, my lord would see, my lord, GST came, my lord, in July 2017, my lord, and my lords would see all the months are covered here. July, August, September, up till March. So, my lords, for all these months, the time limit was extended, my lord. And my lords would see, my lord, just below that, that is very important paragraph, my lord, on the same page. Para 2, may I read, my lord? Yes, my lord. The extension of time limit for furnishing the details or returns, as the case may be under subsection 2 of section 38 and subsection 1 of section 39 of the Act for the months of July 17 to March 2018 shall be subsequently notified in the official gazette.
So in spite of the fact,
yes,
the rules which have, these are earlier ones.
These are earlier ones.
No,
yes,
no, I am therefore saying.
Yes, my lord.
What has happened pursuant to this? Because this is a rule of 19.
My lord, but what happened was this is retrospectively effective. My lord,
From
that
1st
the
of
very
July.
purpose was, my lord, why they introduced this, my lord, because they were unable to bring the actual form GSTR 3. Then, my lord, one fine morning they thought it is better. Let us give sanctity to the return form which we have already called for in GSTR 3B. My lord, 3B was only a summary return. If I may give a brief background, my lord, how they initially conceptualized, they said that every supplier is to report every invoice-wise supply in its GSTR1. So, my lord, if I as a vendor who buyer issue 10 invoices in a month, I will give invoice number 1, 2, 3, 4, and I will give the GST number of the buyer. My lord, that because of giving of GST number of the buyer, it will reflect in the portal of the buyer. Buyer, my lord, would then file GSTR2, thinking, yes, I have received this invoice. That they were not able to introduce. My lord, this was GSTR2. Now, my lord, on the basis of my 1 and buyer's 2, GSTR1 and GSTR2, they conceptualize the third return called GSTR3, because now there is matching. 1 of the vendor and 2 of the buyer, everything matched. Then they said, then there will be a third return called GSTR3, which will be the final return.
Who is going to submit?
Both of them. Both of them would have to submit. So GSTR1 and 2 were called statement. That's why my lord saw that word is, they are using details. GSTR1 and 2 were details and 3 was a return.
And you submitted the GSTR1.
I as a supplier, I submit 1. Buyer has to submit 2. And both of us then, after reconciling the data, had to file return in 3.
But the 3 was not noted.
Neither 2 nor 3. My lord had seen this, my lord. Now see para 2 once again for a moment, my lord. Para 2 on page 287. The extension of time limit for furnishing the details, my lord, which is GSTR1, or return, which is GSTR3, as the case may be, under section 38(2) and 39(1) for July to March 18 shall be subsequently notified. So, my lord, they first extended the date for GSTR1.
No, as per 38(2) will be GSTR2.
Yes, my lord. 37 was GSTR1, 38 was GSTR2, and 39 was GSTR3. No, my lord, their portal was not functioning properly.
So
Even
two was not 2 was not functional.
Not functional. 3 was not functional.
Mm.
So, my lord, what they did, they gave a like a solution. They said, all right, you only continue file GSTR1, and in the meanwhile, rather than matching invoice wise, we give you an option to file summary return, which they called as GSTR3B, which was in addition to 1, 2, and 3. In addition, not in derogation. My lord, for better understanding, if my lord.
So therefore, the fact that you have submitted the GSTR1,
That's right, my lord.
which categorically shows that you have performed your part,
That's
being
right,
the
my lord.
supplier.
Yes, my lord.
So you have already done your part.
I have done my
Now
part.
the second part could not have been done
Could
because
not.
of the GSTR2 was not there.
That's right. And 3
And
was
the
not there.
GSTR3 cannot happen without 2.
That's right, my lord. And 3 was actually not there. They themselves have said, we will extend the date.
Now what is GSTR3B?
Yes, my lord. So since they were unable to bring 2 and 3, they introduced a rule called Rule 61, the amendment thereof which my lords were seeing. My lord, may kindly have, I have made a paper book, my lord, just showing how these provisions have, my lord, flown. It's already there. My lord, may kindly come to, my lord, in fact, it's a very interesting thing, my lord. They have changed it at least 6 times. I have attached every time they have changed it. My lord, may kindly see page 109, where Rule 61 starts.
Of index 1 or?
My lord, I am on index of provisions.
Okay. Page 1.
Page, my lord, it starts with 109.
Okay. Yes.
My lord, this I call as, my lord, version 1, which was only for 26 days and which was then later on removed, my lord. So, my lord, may just note it to be removed, not consider, my lord, because it was retrospectively amended. This is the first version, my lord, on 109. My lord would see, I have also mentioned on the top version 1. My lord, then, my lord would see next page, my lord, version 2, 110. My lord would kindly see that it was substituted by notification so and so dated. My lord, one point, my lord, may notice here, my lord, GST was introduced on 1/7/2017. 1/7. So, my lord, on 27/7, after 27 days, they introduced a retrospective amendment, and my lord, they amended the rule like this, my lord. Then, my lords, they again amended retrospectively from 1/7/17, which my lord would find at page 112. I'm not bothering with these versions, my lord, because they were all retrospectively amended.
Okay.
So, my lord, this is relevant.
From 1/7.
Yes, my lord. With effect from 1/7. My lord, on the top we have noted it. My lord would see retrospectively with effect from 1/7/17. My lord, see that on the heading.
Yes.
Yes, my lord. Now, my lord would see
in Rule 61 with effect from 1st day of July and sub Rule 5 for the word specify that so and so. Now, my lord, I read the rule, how it rules, read, my lord, the heading is form and manner of submission of monthly return. Every registered person other than person so and so, other than is not relevant, my lord, shall furnish a return specified under subsection 1 of section 39 in form GSTR 3 electronically. My lord, sees this, my lord? So the form for return as per their section 39.1 was specified in Rule 61 as GSTR 3, my lord. My lord, notices this, my lord?
Yes.
Now, because of their portal not functioning, my lord, what did they do, my lord? They introduced 5. My lord, so now come straight away to 5 of this, sub Rule 5. Now, my lord, what they say, on the same page it is there.
Yes.
Yes, my lord. When the time limit for furnishing of details in form GSTR 1 under section 37 and in form GSTR 2 under section 38 has been extended, my lord, and the circumstances so warrant, the commissioner may by notification specify the manner and conditions subject to which the return shall be furnished in form GSTR 3B electronically through the common portal, either directly or through a facilitation center. So, my lord, initially they were not required to separately notified every month that you have to file in 3B. They said if we have any conditions, we will tell you by notification. Otherwise, the moment we extend the date of GSTR 1 or 2, immediately you are liable to file 3B. Right, my lord? So there are 2 returns. GSTR 3 is the actual return. Summary they introduced in 3B. And my lord, they said if 1 and 2 are delayed, then summary triggers. But what is the implication, my lord? Would see 6, which is very, very important. My lord, would see kindly see 6 on the next page. Where a return in form GSTR 3B has been furnished. So, my lord, I ask myself, when will I furnish 3B? When there is a delay in 1 and 2, they notify the delay. I have shown one notification, my lord. There were no series of notifications because they never were able to introduce 2. Every month they kept on giving notification. So, my lord, every month I kept on filing 3B. Now, my lord, they say where a return in form 3B has been furnished after the due date for furnishing details in form GSTR 2, my lord, may straight away see where the amount of input tax credit claimed in GSTR 3 exceeds the amount of input tax credit in terms of GSTR 3B, the additional amount shall be credited to electronic credit ledger of the registered person. Meaning thereby, my lord, I had an option as a registered dealer because I have to file return in 3. Actually, as per law, return form is 3. And they have issued notification saying we will be giving you extended date for 3. So I'm waiting for 3. They say in the meanwhile, you keep putting 3B. But if in 3B you take credit or you don't take credit, whatever is the extra credit finally available to you, you can show it in 3. So, my lord, assume for a moment that I did not file 3B or I did not take any credit in 3. But in any case, I had a legitimate notification saying that we will tell you the date of 3. I was waiting for that notification because on that day, I could claim my credit. I am claiming every day in my books of account. My lords, I am a public listed entity of state of the central government under the Ministry of Telecom. I am taking every day. There is no dispute on that in my books, which I have a statutory recognition under the act that credit I have to take in the books. Supreme Court says so. Bharti Airtel. The only point was I had to show it in my return. Now, my lord, 3B was only a stopgap arrangement originally because 3B ultimately had to be followed with 3. And sub rule C of 66160 says whatever is the short amount of credit, I can anyway show it in 3. Now, my lord, what they do is these notifications keep on coming. My lords, may kindly now have O again with me, my lords, page 287, annexure O. I would only show, my lords, that there were 5 such notifications saying we are extending. We'll give you the extended date. My lord, would now come to page number 288, my lord. This is notification after 29 December, my lord. They on the same date, my lord, in 287, they said that we will give you dates for July to 18, March 18, my lord. On the next page, 29 December, my lord, again they say so by way of notification in para 3, the special provision or extension of time limit for furnishing the details under subsection 2 of section 38 and subsection 1 of 39 for the months of July to 18 shall be subsequently notified. They again say so, my lord.
So GSTR 2 and GSTR 3.
That's right, my lord. They again say it on the next page, my lord, would see page 289. By notification of 2018, my lords, 10th September, again in para 2, they say the same thing even up to March 2019 this time, my lord. The time limit for furnishing the details or return as the case may be under 38.2 and 38.9 for the month of July 17 to March 19 shall be subsequently notified. Then, my lords, on the next
Okay,
page.
now what has happened?
Yes, my lord. Now, my lord, while these notifications are in vogue, they have never been rescinded. They issue this retrospective amendment. Now, my lords, may again come with me on Q, which I have, my lord, also put in this physical compilation. My lord, may kindly have from there only. 49 notification is their fourth version, my lord.
Okay, then what happened?
Yes, my lord.
I have understood. Yes, then.
My lord, what happens is, because of this amendment, my lord, because of this amendment of 49, which is at page
So you submit your GSTR 3B.
Now, my lord, I am submitting only 3B because 3 has now been done away with. What they say is, in this notification, my lord, what they say is,
Where?
page 114 of this compilation, which my lords are holding, index of provision. Lord, the very same compilation from where I was showing the rule, page 114.
Yeah.
My lords, because of this retrospective amendment, my lord, sub-rule 5 stands substituted now, my lord, and they say, earlier, my lord, there was 5 and 6 both. My lords have seen 5 and 6. 5 said that I have to file 3B and 6 said after 3B I have to file 3. Now, my lords, first thing, my lords, on page 115, my lord, would see they have omitted 6. My lord sees that? So, my lord, now there is no 3 after 3B. Retrospectively, they say. So, my lord, I was waiting that 3 will come and I will show the input tax credit. They don't give me 3. They say 3B, which was a makeshift return, will now become the return. And they delete 3. Because of this, my lord, actually I am unable to show credit
of that those
of that period,
of those remaining portions,
of that remaining portion,
which you had the opportunity
which
to
I
show.
had the opportunity and which I still have, my lord. Why, my lord? My lord, according to me, my submission is these notifications which I have shown to my lords in annexure O, they are still standing. It is duty of the CBIC to notify those extended dates so that this problem cannot be there. My lords, today I am having litigation, my lords. The public sector undertaking is embroiled in litigation. Guwahati, my lord, Arunachal, Meghalaya, my lords, Patna, my lords, West Bengal, and my lords, 2 of the courts have, my lords, come to my rescue and they have, my lord, given us interim orders, my lord, Arunachal and my lord, Meghalaya. My lord, this is the problem which is typically coming, my lord, where, my lord, therefore this problem has to be
Now let
removed
us
from the
see what is the so-called here.
Yeah, that's right. My lord, the order,
Have
my
you
lord, would
challenged this notification?
I have challenged. This 49 I have challenged.
You have challenged the rule.
I have, my lord, I have challenged this notification.
Because these notifications by date,
yes, my lord,
it's an amendment to the rule.
That's right, my lord, I have challenged this also.
You're challenging the amendment to the rule.
I have challenged this amendment. That is my first, my lord, first prayer, my lord. First prayer.
Now, this amendment to the rule,
yes, my lord,
this notification, I will come to page 303.
303, my lord, yes.
Hereby make the following rule further to amend it.
Yes,
so
my lord.
isn't this a challenge to the rule?
That's right, my lord.
It's a statutory rule.
It is a
So wouldn't this go to the division bench? What notification? By way of it is notified. It's only notified, but isn't it a challenge to the rules? No, this is a challenge. You kindly see page 302. The central government hereby makes the following rules further to amend the central government goods and service tax rules 2017. So it's a rule being challenged. It will go before the division bench. Huh? Taking into account that the rule has been taking into account the statutory rule, the central taking into account that the instant repetition, the amendment made to the central goods and service tax rules 2017, which in effect an amendment made to the Central Goods and Service Tax Rules 2017 has been put to challenge, which in effect challenges the present Central Goods and Service Tax Rules 2017. List the matter before the division bench.
Lord, please fix it on a particular.
The registry shall place it before the division.
Grateful.
17/2017. It's a challenge to that rule itself.
And he was telling me earlier was that subordinate legislation.
It's not a subordinate.
It is a subordinate only.
It can't be sub. It is a challenge to the rules.
How in CGST Act, the Act of Parliament is Central Goods and Services Tax Act 2017. Under the power of that act, rules have been notified. So, my lord, that is definitely a subordinate legislation that I can show. Only to avoid.
No, it is a subordinate, but it is a challenge to those statutory rules.
Definitely it is statutory, my lord, but
So
not the
if it
parent
is-
act.
No, it
We
is
are
not
not
to the,
challenging
no,
the
no.
parent.
It is not only to the act, even a statutory rule is to be
Lord,
there
as
before
per
the
my
division
friend,
bench.
I don't know, my lord, the system here, but
As per our limited knowledge of understanding.
I think the statutory rules is before is to the division bench. Okay.
So the Meghalaya High Court, there was a single bench. Meghalaya High Court.
Who?
It was a single bench before the Meghalaya High Court. The other
Meghalaya High Court is not our High Court.
not sorry, my lord, Itanagar bench.
Let's keep on the Guwahati High Court.
Guwahati High Court.
A writ petition in which constitutional validity of any act, rules, or any provisions have been challenged. The rule will be before the TV.
grateful. Great. Thank you. Thanks for the interview.
Yeah.
But a petitioner has inherited a plot of land and under revenue title bucket, and they have mutated their name after the death of
Who is creating disturbance to you?
Khetri police authority of Khetri.
Police authorities is creating disturbance to you.
Lordship.
Show me that.
Actually, Lordship,
You have written it to some authorities. You have got some status quo order.
Lordship, actually, respondent number 6 is island title there, and injunction order has been passed. Lordship,
Then
Lordship will find the injunction order at Lordship. Yes,
then what has happened?
and Lordship 54 Lordship.
And what is the step? Authority is doing.
We are in possession Lordship. We are still in possession Lordship. We are trying to proceed in possession.
Who?
Proceed operated police.
In spite of a status quo order.
Lordship. Lordship.
Then why are you not complaining before the authority, before the competent court?
Lordship,
There's a status quo order. If anything happens, you can very well ask for an injunction. The injunction you can very well do under Order 39, Rule 2. Being a defendant, you are a plaintiff or a defendant.
Lordship, defendant.
The defendant can very well file a injunction application. If there anybody is disturbing your possession, then why are you before this court in the name of the officer in charge? Let's see what have you filed the FIR. Most respectfully, it is submitted in the morning. Accused person secretly trespassed into the land from the husband and possessed the area. It is stated that the aforesaid land was purchased 20 years ago from the husband of the man, but due to illness of the husband, the land not be registered, and the accused person taking advantage of the head prosperity are deported. When the accused person were asked about the matter, they stated to various years, therefore, then, and you have written to the commissioner.
Noted.
Like to yes, madam. If it is a case of the as there is a dispute going on, a private dispute going on between the petitioners and the respondent number
6, my lord.
6, these officials should not do anything.
Yes, my lord.
Isn't
As there is a status quo.
So we dispose of this petition with a direction to these officials not to interfere in the private dispute between the
Till the
petitioner and the
disposal of-
respondent.
Obliged.
The instant petition has been filed, is taken up for disposal at the motion stage itself. From a perusal of the petition, it revealed that there is a private dispute pending in respect to the land in question between the petitioner and the respondent number 6. It is also seen from a perusal. It is also seen from the records that a suit has also been filed, being title suit number 103/2022 before the court of the Municipal number Municipal number 2, and before the court of the Municipal at Kamrup Metro at Guwahati, and is presently pending before the court of the Municipal number 2, Kamrup Metro at Guwahati. It is also seen that there is a status quo order being passed by the said court on 3/3/2022. The record further reveals that there are certain that the respondent number 7, respondent number 6, the record further reveals that allegations have been made that the respondent number 6 is trying to dispossess the petitioner from the land by unlawful means for which an FIR has been filed. And there has been no action taken by the officer in charge of the Khetri police station. It has also been alleged that the Commissioner of Police, Kamrup Metro, has also been intimated by the communication dated 21/2/2024 to the effect that the respondent number 6 have been taking steps to evict the petitioner, and in that regard, the police personnel of Khetri police station are pressurizing the petitioner and threatening to dispossess the petitioners from the plot of land. This court, taking into account that there is a dispute pending before the competent court as regards the land in question, would not like to comment. As regards the rights of the petitioners vis-a-vis the respondent number 6 over the land in question. However, it is relevant to take note of that when there is a private dispute between the parties and the matter is pending before the competent court of law, the respondent, the police officials should stay their hands away from such dispute till the competent court of law duly decides the same or passes appropriate orders in that regard. With the above observations, therefore, in that view of the matter, this court directs the officer in charge of Khetri police station to ensure that no interference is caused to the private dispute between the petitioners as well as the respondent number 6, which is presently pending before the competent court of law, till any appropriate orders are passed by the state court or any other court in that regard. With the above, the instant petition stands disposed.
Okay.
Item 12.
Yes, Mr. Bhatti.
My lord, I have challenged the validity of the order 29 plus 22, passed by the regional officer of the pollution board, my lord, directing me to go down my intensity like the consent from the board, my lord.
You have been asked to stop till you obtain the pollution. You have the pollution.
No.
Then?
There is no question, man.
Huh?
Without anything, man.
No, do you have the pollution?
No.
How can you do a pre-clean without a pollution control board?
Because I have already applied for it. And that
Barely applying would not help
yes,
you.
my lord. My lord, my question, my submission, my I have already applied for the consent, my lord. The consent has to be given within 4 months. Either it has to be.
No, it has the pollution control board norm stipulate about the deemed consent.
Deemed consent, my lord, according
to me.
Yes, my lord. Let us come to section 21, my lord.
Of the
air
pollution,
and control of pollution.
Environmental law. Who is appearing for the pollution control board?
Asif, I'm appearing as Gora Lord. He is out of station due to expire with Uncle Lord.
Oh. So we'll have pollution control board is not represented.
Representing.
Who is representing?
No, I'm appearing on behalf of him, but he is unable to appear, Lord.
You are appearing for somebody. Yeah, A8 of air pollution.
There's an instruction from the pollution control board.
What does it say?
That say that the board rejected his consent, Lord.
Okay.
When it was rejected, it was not
You
communicated.
challenge it, এখন মুখৰ কিমান লেতেৰা
My lord, may I?
It is already communicated to the petition.
No, my lord, I did not. Now, my lord,
Show me section 21 where
21. Air permission 21. Subsection 4, my.
get line.
May I
Okay, you
read?
have a copy? Air pollution?
Yes.
Because yes.
Subsection 4, my. That is important. That is within the period of 4 months. After the receipt of the application of consent referred in subsection 1, the state court shall by order in writing and for reasons to be recorded in order grant the consent applied for subject to such conditions and for such period as may be specified in the order or refuse such consent. My the outer limit is 4 months. Now, my lord, your lordship will see. Second proviso. Provided for provided further that before cancelling a consent or repeating a further consent under the first proviso, a reasonable opportunity being heard shall be given to the person.
21. The reading provided it shall be open to the state board to cancel such consent before the expiry of the period for which it is granted or refuse further consent after the expiry if conditions subject to which the consent has been granted are not fulfilled. Provided that before cancelling a consent or refusing a further consent under the first proviso, a reasonable opportunity of heard to be given to the petitioner.
That is the provision, in this particular case. No opportunity was given to me by the prior to passing of the order, impure order.
Which order?
Yes, ma'am. At page 20.
Page?
Page 61, ma'am.
61.
May I read it, my lord? This is reference to a public complaint. Issued from the chief operating officer, such. Again, your pre-clean unit, which is operating as such and such. Sir, the complainants have alleged that the site is located nearby their footpath. It is a difficult task for them to comply with the basic requirement hygiene and food safety aspects of their project.
Then?
That
is of 2022. 2 years have passed.
Yes, my lord.
Then?
This was passed.
Then what happened? Have you challenged this on?
Now I'm telling you.
In 2022, 24.
24, my lord.
And what is this? Another petition I've seen in 2023, another petition filed.
Now your lordship will come.
Kindly come to page 68. What is that? What are you challenging?
68, my lord.
Is withdrawal.
Below.
Then page 60, 71.
71, that is the order. Which was passed in the meantime. No demolition may kindly take that by. That was the oldest part.
This is for demolition. Now,
No,
what has
sir,
happened
not
to
for
this?
Demolition, madam.
Huh?
It was not for demolition.
But there is no order for anything else. You have not been allowed to continue.
So in fact, there is a order not to
Only
operate.
29.
In that case, my lord, another order, they are not to operate. There is distinct order from this honorable court not to operate.
Where is it?
That is not in annex, my lord.
Why?
No,
It
which
is
one?
annex.
My goodness.
Hmm?
Mr.
No, my
Bhatti.
lord,
And that when I write
Who is
it, my-
appearing for here? Imam. You are the same person.
same person, my lord.
Then why you have not enclosed this?
Which-
That the interim order is only regarding an attempt to demolish there. However, a petitioner is directed not to operate the same
Yes.
till the next day.
no,
Then it is
I was
continue.
not operating, my lord.
Then,
I was not
Then he
operating.
operating, we inform
And
the court, then he withdraw.
what do you want now?
Now, my lord, I want the stay.
Hmm.
Because your lordship will come again to stay 61, my lord.
Hmm.
This order, the reasoning which has been given in the order, my lord,
Hmm.
that is on the complaint of a private respondent, my lord. And that too without making any kind of inquiry, my lord, first of all. And after that, this copy of the said complaint was not supplied to me. I was not asked
Hmm.
to so code.
Hmm.
And without doing that one, my lord, they say that you cannot carry on the activities, my lord. Apart from it, my lord, subsequent to it,
And there is an order of the board on 2/6/2023
that is, my lord,
for
it was
you
not
not to
supplied
operate.
to me. It was not supplied to
So
me.
without that, where your board, where the board also had rejected your consent to operate application by number so and so on 3/2/6/2000 in view of the above stated court case.
That is available order.
My lord, that copy was not supplied to me, first of all. Secondly, no opportunity was given to me as provided under section 21 of the Act.
Hmm.
Prior to cancellation, no opportunity was given. Apart from it,
Were you earlier operating with a consent?
yes, no, not consent. In fact, my lord, the consent was not granted
At
But
any point of time?
at any point of time.
And you are cooperating?
In 19, since 19. And since 19, I have been
But this act came into being in 1981.
81.
Then?
But the rules were made in 1991. My lord, what I am submitting, my lord, that so far the fee is concerned, I have been paying.
Mr. Bhatti, high time you should have all these papers together and then properly file and challenge it. Don't you think so? All these things, now taking into account this one.
My lord, that was not supplied
So,
to me at all.
as of now, when this court has the knowledge of it, so can this court now pass any order to you if you don't challenge that? Tell me.
No, that is right, my lord. Your lordship is absolutely correct. But what is the position here, my lord? Until and unless the copy of it is supplied to me, my lord.
The copy has been addressed to you.
No, it was not delivered to me, my lord. Where is the question that they delivered it, my lord? Where is the evidence, my lord, that they delivered the
So what
copy
do you
to me?
want?
My lord,
You can't get anything else except merely a notice, but merely a notice does not serve your.
no, that would not serve my purpose. Stay is a must of this.
Huh?
Stay
Stay for what?
for 29th order, my lord.
For what?
For 2 reasons.
No, stay for what? Means so that you can continue.
Yes, sir.
Wouldn't that be in conflict with the order being passed by the coordinate bench out there saying that you are not to operate?
No,
Where you are appearing and you have not
that
disclosed the
is-
same in
my lord, that
petition?
petition have already been withdrawn by me, my lord.
You have withdrawn?
Yes,
When?
that is the order, my lord. I annex. Order page 68, my lord.
And there you have challenged where? What have you challenged?
In that particular, I have challenged only
Hmm.
the order dated 17/1/2023, my lord.
17/1/2023. Which
That you
order?
also will find at page 65. Page 65.
So you have only challenged that. So now you are challenging everything. I think you will need to further withdraw and challenge these also.
My lord, definitely had it been supplied to me,
I
could have
can't
challenged.
help you, Mr. First of all, when there is an order being passed by this court not to operate, then
No,
by
but I'm
withdrawing,
operating.
withdrawing the writ petition and
No,
getting a
no,
liberty,
no,
do you
no,
get
my
the
lord, I
right?
am not operating. So far, the clean is.
No, no, the moment you are asking for stay means you will operate.
Yeah,
Eh,
yes, my lord. That
Then,
is, that's
anyways,
why I have come for it.
what should I do now?
My
Should I
lord,
dismiss
your
it?
lordship has to keep
Dismiss?
on the case of the order dated.
No, order, this court, first of all, is sitting in 226. And sitting in 226, you have not, you have not produced this order, which is very relevant. Have you mentioned that there was an order being passed by this court, by the coordinate bench to that effect that you should not carry out
No, I
operation?
have not.
Then, isn't it a case of suppression of material facts?
My lord,
And then now you are asking, the moment I stay that, on whatever grounds you are saying, wouldn't that be allowing you to operate?
no, my lord, on the basis of that is petition, man. In that is petition, the order dated 29/12 was not challenged at all. They challenged only the order dated 17/1. And that was the reason, and since I have already withdrawn the writ petition, man. In that case, your lordship, each and everything has done with it. Withdrawal means I have not filed at all any writ petition. So that your lordship may reconsider whether the order is valid one on the case of
Which order?
29/12, which has been passed by the respondent number 3.
Now, first of all, when did you apply? Your application has been rejected.
My lord, no
First of all, how did you at all start manufacturing or using a brick kiln without a permission?
my lord, since for this particular purpose, may I take your lordship to certain documents? First of all, my lord, your lordship will see the payment which I have made at page
24.
24. And that was payment.
So in the year 2019, you have sought for that
Right.
permission.
Thereafter, I also made the payment, my lord. Your lordship will see at page 37, my. That was and 10,000 for 2 years, my lord. And thereafter, your lordship will see. Yeah.
Renewal consent. When did you get your consent?
My lord, once the consent is not given within the 4 months.
It's deemed.
Yes, my lord, either it has to be rejected or to be granted. And the both things are not done. What could be the inference? Now, my lord, this one, 40, page 40, 2023, my lord. And thereafter, my lord, your lordship will see. Next page, 49.
This is applying.
Yes, that is a new application. Renewal or new application is one and same thing.
Then
So that it is not there, my lord, that I have not applied for the consent. They allowed me to continue with my lord till 2022. And after that, I completed all the formalities, my lord. Now they have come with the plea that they have already rejected my application. In that case, my lord, the question of giving the opportunity.
when did you construct?
It was constructed in 1976, like that one.
Huh?
It was constructed Like, it was constructed by a different person, my lord. Later on, I purchased it in 19.
Mr. Bhatti, kindly come to Annexus C,
Yes.
page 27.
Yes.
This is a lease agreement with some Hiranyasakya.
Yes.
Now kindly come paragraph page 28. Whereas the lessee, that is you, would
Yes.
like to take a plot of land of 3 kathas so and so out of so and so, so and so, so and so. Whereas the lessee has proposed and proceeded to set up a brick industry. So, what are you saying about 2076 or something? When you have entered into an agreement in 2019?
19 later. My lord, because I have it in paragraph. You will see it was in a different name. Subsequently,
Okay, now to dismiss. Now the question is how much cost? We are now deliberating on cost. This is a very serious thing which you have done. Dismissed, okay. The problem arises when liberty is being granted, no? In this manner. When there is an order being passed not to operate, you withdraw the merit petition and with a liberty and again file.
no, for that reason.
And you have not enclosed that order out here.
No, my
This
lord,
is a
I
very
have not
serious
gone-
thing.
I have not gone through that particular order, and I have.
Ah,
not
you
withdrawn.
know it very well.
No, and for that reason, I have not.
You know that there is an existence of an order to you. I'm not saying,
Yes.
Mr. Bhatti, about you. Your client very well knows about this order not to operate. Because at her instructions that the case was withdrawn. And isn't it a very clever ploy out here that you have withdrawn the petition when there's a direction not to operate? And then again with the liberty and then again approaching this court.
No, my lord, that is not the thing. So far, what has happened in this particular case? The earlier
In the year 2019, you proposed to set up a brick factory.
Yes.
As on that day, did you apply for consent and did you get a consent? If you have not got a consent, you
Yes, my lord,
cannot
I
operate.
paid the consent fees, my lord.
You have
And
not.
the-
No, you have paid whatever may be. That is
I
that is a different aspect. I'm not on that.
And my
The question is making
I
payment. It's
I-
not a deemed unless the statute permits.
I applied for it, my lord. I paid the fee. I paid the fee, and it says so that I paid.
So you have to ask for that you should be given a consent. They are unnecessarily refusing your consent. That should be your case at best.
My lord, in this particular case, since 19 to till 22, I carried on the business, my lord. Now,
Isn't there any scope of imposing an environmental cess on polluting out there?
my lord, that is the difference.
No, that is the cost.
No,
No, I am on Mr. Bhatti, I am on the cost. I have forgot about the dismissal is there, but the cost is on the environmental assessment.
my lord, in that case, my argument may kindly be recorded. What I am going to submit in this particular case. First
Yeah.
of all, so far the section 21 of the Act is concerned, my lord, that provides that my application for consent has either to be granted or the consent has to be refused within the period of form. Now, my lord, if the consent neither is granted nor refused within the 4 months from my making the application, in that case, the inference would be that there that deemed the permission to start the case. Accordingly, they allowed me during the 2019, 20, 21, 22 to carry on the business. Now, secondly, my lord, in case of cancellation or refusal, the permission, the opportunity, statutory opportunity.
Mr. Bhatti, kindly tell me there are two aspects. First of all, you entered into the agreement in 2019.
Right.
So you must have for the purpose of constructing the bricklane, you must have sought for permission. So this 54,000 which you have paid was for the purpose of establishment. Couldn't have been done otherwise. You see, when you start an industry, there are two aspects where the pollution control board comes into the picture. The first is when you apply that I am going to set up. So there is a consent given prior for the purpose of setting up. Then comes, once you have set up, there will be an inspection being carried out. And then the second permission is being applied for the purpose of going ahead with the operating the.
No, my lord.
Yeah.
So what is setting up is concerned by.
You did not.
No permission is required.
Why? Who says?
The act itself.
No, it is required.
21, my lord, it itself says my.
It is
Otherwise,
required.
if I am going to start the business by set up any other industry, later on, my lord, after setting up the industry, when I make the application, they will refuse.
It is required. For setting up also, you have to take the permission.
No, my lord, for that particular purpose, may I take your lordship to the rules, my.
Hmm.
I have the copy. Rules does not say static. Neither the act nor the. Directly, my lord, I am taking to your lordship. To
Kindly come to, forget about the other thing. Kindly come to section 21.
Yes.
Subject to the provisions of this section, no person shall, without the previous consent of the state board, establish or operate any industrial plant in air pollution control area. Meaning thereby, establish, you cannot establish, set up without a permission first, and then it is subsequently followed by a consent by which you are allowed to operate. In the first permission, it will be very well given that while you are making this construction, these are the things which are there. Now we are handicapped for the fact that the Pollution Control Board Council is not saying anything, but this is how it is done. So you, for the purpose of establishment, you need a permission. You cannot. Therefore it says establish or operate.
establish or operate.
Yes.
Operate. Then, my lord,
Both, for both.
either of the things.
No, both. You require both.
Either
For,
of the
for the
things-
purpose of establishment, therefore the State Pollution Board grants a very well a permission out there, saying that for only for the purpose of air, once it is being done, because you will have a chimney.
Huh.
Once the chimney is there, then the chimney, in that first permission, it is mentioned that the chimney shall have all these things. And thereupon, when you apply for the second one, then they will make a they will check out there what is the how much is the pollution and all. Then they give you the operate. This is how the manner it is.
My lord, my submission establish or
You need
so far the operation of it, because it was established for this purpose.
establish means you, without that permission you have established.
Yes, it was established when my lord, this act.
And in fact, this has caught my attention because of the challenge which you have made earlier, to 17/1/2021 or 22. Where is that document? Page? Yes. Kindly see 17/1/2023. No objection certificate issued from the office of the Imam, and there is a case pending. What is this case?
My lord, file, my lord. Actually,
my-
my lord,
let-
without
let me
consent, he has, my lord, operated, my lord. Then district
My-
administration said you stop it, and that has been challenged. That is means district for default.
Let me submit it, my. This case, Tera 18. May I take your lordship? Tera 18 of my petition, my lord. Tera 18 of my.
Okay. What to do? Mr. Bhatti has said so much of things. I think this is the best case for issuance of a slight notice. Nothing more than that. Only a notice. But this is. You file a affidavit. State bringing on record those facts. Issue notice making it issue notice making it returnable on 1st of March 2024. Mr. Environment who? Mrs. M. Kulja appears on behalf of the respondent number 1. Mr.
2 and 3. Kelly sir.
So appears for respondent number 2 and 3. And M. Borman appears for respondent number 3, 4 and 5. And you are 6. Mr. T.J. Mohanta represent the senior counsel assisted by Ms. Wento. T. appears for the respondent number 6. As the respondents are duly represented, extra copies of the writ petition be served upon them by 18/1/2024. The petitioner herein have assailed the order dated 29/12/2022 passed by the regional officer, RLO Tejpur Pollution Control Board, whereby there was a direction to the petitioner not to carry out any activities as to the running of her brick-kiln industry till the consent is granted by the Pollution Control Board, as well as the order passed by the Circle Officer Moholdoi, dated 17/1/2023 for stopping the functioning of the brick-kiln industry of the petitioner, with Raj Brick-kiln. Full stop. This court, upon hearing the learned counsels for the parties, and also taking note of the fact that the petitioner, before establishing of the brick-kiln industry, had not taken the permission to permission in terms with section 21 of the Act of 2000 of the 21 of the Air Bracket Prevention and Pollution Control Air Bracket Prevention and Control of Pollution Bracket Close Act 1981, and also for the purpose of operating the said brick-kiln industry have not yet received any permission from the Pollution Control Board, directs that the petitioner should not directs the petitioner not to operate the said brick-kiln industry till further orders being passed by this court.
My lord, only one thing. They may demolish my clean. So
they are not going to demolish.
I don't today, my lord.
Yeah, that is not your prayer also.
That is not a prayer. But even though, my lord,
they are not going to demolish. If they come up for demolishing, then we'll see.
By applying order 727, my lord, your lordship may grant me. Till then, my lord, status quo as on today, my in respect of that.
No. This is, first of all, they are not going to do anything. Don't worry. And if they do anything, we'll see. I've asked you not to operate. In spite of that, I think the Pollution Control Board won't do it.
My lord, furthermore, my lord, so far the interim prayer is concerned.
What interim? I've asked him not to operate, and you are saying until further orders from this court, and you are saying interim order to be considered.
Even though, my lord, that matter may kindly be heard.
Sorry. Nick.
55.
Yes, what is this?
Yes, yes, sir. Okay, as per the instruction by Guardian Council in this matter, my senior is giving submission before the court on 10.
Oh, this one.
Yes, I have
Yes,
the
but
instruction.
what instruction you got?
The connection was disconnected at the request of the owner of the premises.
Okay, then by way of delete that, we
Yes,
can
that will apply, my lord.
direct it.
Yes.
We allow
insist-
your petition. You have objection? You have objection? No.
So without insisting on an NOC, ma'am.
Eh?
Without insisting on an NOC, we might be directed to give the.
The instant with petition is taken up for disposal at the motion stage, taking into account the facts involved. The petitioner herein is admittedly a tenant of the respondent number 5. Full stop. In the writ petition, there has been various allegations being made that the respondent number 5 wants to evict the petitioner without following the due process of law, for which a suit was filed before the court of the Civil Judge Junior Division number 1, Dorong, Mongoldoi, which have been registered as title suit number 146/2023, praying inter alia that the petitioner should not be evicted from the suit premises without following the due process of law, and have also sought for a mandatory injunction that the respondent number 5 should pay the electrical bill of the suit premises so that the epidicial authorities do not disconnect the electrical line in respect to the suit premises. It is also pertinent to take note of that along with the said suit, an injunction application was filed seeking an injunction, thereby restraining the epidicial authorities from disconnecting the electrical line in the suit premises. The record further reveals that the trial court, by an order dated 2012-2023, issued notice making it returnable on 17/2/2024. However, there was no ad interim injunction, ex parte injunction granted in favor of the petitioner. Be that as it may, pursuant to the order being pursuant thereto, the electrical line of the petitioner was disconnected by the respondent epidicial authorities on the instructions of the respondent number 5, for which the instant petition has been filed. When the matter was listed before this court on 10/1/2024, this court had asked Mr. B. Chaudhary, the standing counsel of the APDCL, to obtain instruction as to why the electrical line was disconnected. Today, when the matter has been listed, it has been the Mr. B. Chaudhary, the learned standing counsel of the APDCL, had submitted that the respondent number 5 is the consumer of the electrical meter, and the electrical bill was not paid for the months of November and December 2023. For which the respondent number 5 was duly intimated and pursued. Subsequently, the respondent number 5 had applied for a permanent disconnection in the month of January 2024, and the APDCL authority had therefore disconnected their elect connection from the premises on 3rd of January 2024. It was categorically mentioned that in respect to the dispute between the petitioner and the respondent number 5, the APDCL authorities have nothing to do with their internal conflict. And as the connection was in the name of the respondent number 5, and there was a request by the respondent number 5 for permanent disconnection, the same was carried out. This instruction, so placed before this court, is kept on record and marked with the letter X. Good stop. Now, what to do? How are you going to give it to him?
Let him apply for a separate electric connection for us. And we will.
Mr. The learned counsel, this court have also taken note of the judgment of the Supreme Court in the case of Dilip bracket dead through LRs versus Satish and others, reported in 2022 SCC Online SC 810, wherein the Supreme Court had in paragraph number 9 categorically observed that it is a well-settled position of law that electricity is a basic amenity of which a person cannot be deprived. It was observed that the electricity cannot be declined to a tenant on the ground of failure or refusal of the landlord to issue no objection. All that the electric supply authority is required to examine is as to whether the applicant for the electric connection is in occupation of the premises in question. Taking into account the above, this court had also put a pointed query upon the learned counsel appearing on behalf of the petitioner as to whether the petitioner would be agreeable for making application for a separate connection. The learned counsel appearing on behalf of the petitioner submits that the petitioner is agreeable for applying for a separate connection to his premises. Taking into account the above, this court therefore grants the liberty to the petitioner to submit an application before the concerned respondent APDCL authorities, and on such application being filed, the respondent APDCL authorities shall, in accordance with their rules and regulations, provide a separate meter to the petitioner, subject to payment of the necessary dues.
Well, without insisting on an NOC. So that again will be a problem.
Further to that, this court makes it very clear that the respondent authorities, APDCL authorities, shall not insist upon any NOC from the respondent number 5, taking into account the law laid down by the Supreme Court in the case of Dilip death Supra.
If this is
Meet your lordship. Yesterday, my extraction. I have received.
What has happened? 41(6). You can remove that bank name.
Lordship,
You are the person.
lordship, as per the 12(2), lordship, may kindly have a look at extraction for a moment.
Section 12, your change of name.
Next is the question I have asked them. They have replied,
Amendment of the bylaws shall have to be adopted by resolution at the meaning of petition. It will be said. So the AGM has to be held.
Lordship may submit one.
Yeah.
What is the locus of the petitioner to file this petition? Is the MD, that means he's the secretary of the earlier board of directors. And what is his locus to file this petition?
Now, his bank is not being able to operate.
He's not a bank, my lord.
It's not a bank.
Not a bank.
We are not bank.
Huh?
We are not bank.
What are you doing?
You're not the credit and trade society. Credit and trade society.
You are only dealing with your members.
Yes.
Yes.
That's not important. Not proper.
Regarding the holding of AGM lordship, I spoke to the registrar today morning. He said within 2 months it can be done because they have to go for the voter list also. That's what the voter list. Within 2 months that can be.
Now, if we pass an order
My lord.
to the effect that their only problem is that bank name.
My lord.
So if the bank name is not being used
Lord.
in any communication, till then,
Till the next AGM. Lordship was appropriate order. I instructed him before my lord.
what do you think?
Protect that.
Don't use it.
Otherwise, you will say what name we will communicate.
Put it, whatever name. Don't use it. Don't communicate. Who are you to communicate?
Ultimately, your that is the registered name.
So then don't use this particular account because after all, you are a bank. You have there has been various directions also passed by the court. They're not to use the name bank, and this has been going from 2017. Why is it that till now it has not been corrected? And you have obtained your managers have obtained the stay. Luckily, I vacated it.
That is the reason why.
And you were the respondent on the other side.
Lord.
You know it very well.
Lordship, we know it.
Yes. You
But
were
your Lordship,
appearing.
since there
You
is
know, on that day, Mr. P.T. Goswami was appearing.
Yes.
And his name also glaringly appears here.
Lordship.
So you knew all this quite.
Lordship, what has happened, your Lordship? Immediately after your Lordship vacated the order, your Lordship. In the meanwhile, your Lordship, this probably, your Lordship, the board has, your Lordship, term has left, your Lordship. And one-man committee has been constituted. What I have not understood, one-man committee of the board is constituted by the government. They themselves could take a decision, your Lordship, and then put it to the. Then nobody takes a decision, your Lordship. Suddenly, your Lordship, this order has been passed.
No, obviously that has been rightly passed. The order doesn't require interference. Order is right because you have been not asked to. You have been specifically asked not to use the name bank. But then also you have been doing it by obtaining a stay order from this court.
No, your Lordship will kindly see one aspect, your Lordship. The board of directors terms is elected. Now, your Lordship, government appointed a one-man committee from their officers, your Lordship. Now, they are functioning as a board. So, they could easily take a decision, your Lordship. So
No, they will take that. Will take. I'm not on that. That is a very simple thing.
Lord.
The court will direct them to complete the day within 2 months.
Lord.
That I will direct them. I'm not on that. But what to do about the interim thing?
Only, your lordship, we are concerned with this account, your lordship, nothing more than that. This order.
Accounts, what you maintain in the account?
Your lordship, money collected from these your lordship shareholders, your lordship, that is deposited.
And then what do you do?
No, your lordship, it was invested in some your lordship fixed deposits, etc. Your lordship, then out of that return, your lordship, it was.
And what is it going to happen for 2 months?
2 months, nothing
Your
will happen.
lordship, that money will come, your lordship, where shall we keep it? Your lordship? Where shall we keep it?
But
Because account will
no,
not
you
be,
you can
and-
receive.
and if
You want the problem? You can receive the money.
we can receive, but where will we keep it, your lordship?
No, you can receive only. We can very well direct the account holder. What is the order passed?
61, lordship, page 61,
Last line, your lordship.
that paragraph.
In all the bank accounts of the society being maintained in
in
different
interest
bank,
The shareholders and the depositors of the entity hereby order that the transaction of the bank of the society be
it should be different branches, your lordship.
Where?
Are
until
kept in abeyance.
compliance of the
Now it will be complied by the,
Now, why do these members deposit the money?
your lordship, they deposit this money, your lordship, and your lordship.
Why?
Because your lordship, since it's a credit and free society, your lordship, they can, your lordship, the shareholders deposit, and after depositing it, your lordship, the society invested in different,
Why do they deposit?
because these are the schemes, your lordship, there are schemes under the society. It is like recurring deposits.
But no one of the shareholders have come
Yes, my lord.
causing any difficulty.
Because
Yes.
your lordship, shareholders will not feel the difficulty, your lordship. They branch will feel the difficulty, your lordship, because
No,
shareholders' money will come.
branch is okay. But the branch knows it very well that this is your fault. From 2017, 15 onwards, 16 onwards, you have been waiting out there.
Lordship, there is stay order, your lordship.
Understood. You have been very clever to get the stay order to the manager.
Lordship, stay order is not by the society, your lordship. It is by the
Understood.
rightly or wrongly, your
No,
lordship.
the order was passed without taking into account that the person who has to be aggrieved was that person. And this is the consequence one has to follow.
No, your lordship will kindly see your lordship's order 13/10/2023. And at that point of time, your lordship, the regular board was not there. That's the problem. Had it been there, your lordship's order would have been, your lordship, as part of your lordship's order, board would have a decision, your lordship. From May onwards, your lordship, it was written on behalf of the society to the authorities then.
Why didn't you challenge the direction of the AR Reserve Bank not to use the bank? Why? Till now. It was done in 2015-17. Then why didn't you challenge?
No, probably your lordship.
You took the ploy of those managers saying that they are going to lose the various benefits if this is not a bank. That was the submission which was made by the earlier council. I still remember.
Lordship, one aspect is that. That's your lordship. Probably your lordship, we can't use that. That is clear. We can't use that for bank. Since it is not your lordship, we don't have any license for bank. Cannot. But it is a peculiar circumstances they have been using it, apprehending that in change of name may create a law and order situation that has happened in 2005 and 6 when the RBI, your lordship, withdrew the, your lordship, temporary license granted in our paper. That's the only apprehension.
No, now the law and order does not happen because we have a very state law.
Maybe your lordship, I don't know.
No, we have.
Therefore, your lordship, within 2 months, your lordship, nothing will happen.
No, nothing will happen. No, because you will be taking the help of this court's order and then doing anything, and anything expended out there will have far-reaching consequences. Tomorrow, those investors may very well come. That because of the name has been put as bank, so therefore we have come.
No, your lordship may kindly see, your lordship may do directions, your lordship, in the first meeting itself, your lordship, after the annual general meeting, your lordship, in the first meeting.
And there is no quorum tomorrow, then what happens?
No, your lordship, in annual general meeting, there will be quorum. Your lordship.
How do you know?
No.
That is what the many cases are there where the AGM, the quorum is not there.
But in
4,000 people are there, only 30 persons will appear.
no, here, your lordship,
You need 10%.
till date, your lordship, that has not happened in this particular society.
No, they may, because of the 10% thing is there.
No, your lordship, that will be your lordship. So only your lordship, my prayer is that your lordship, this part, your lordship, this bank account may be allowed to be operated.
We
and
do one thing. We issue notice and direct them to complete the area within 60 days
6 days.
and fix the matter on that,
Lordship.
giving liberty to the investor to file appropriate application if they are.
Lordship.
Lord.
My lord, my lord.
That is the best.
Lordship.
I'll come at 2.
Lord.
Lord.
Is the best.
My lord.
Eh,
Supplement the list for judgment item number 53 and 50.
In view of the above observations and findings, this court therefore is of the opinion that the Commissioner of Taxes, it should be the additional commissioner, was justified in passing the order dated 11/8/2015 for the assessment year 2005-6 by setting aside the appellate order dated when passed by the respondent number 5. This court further is of the opinion that the common order passed by the additional commissioner of taxes dated so are in accordance with law for which no question of interference is called. Accordingly, the court does not find any merit in both the writ petition for which both the writ petition and interim order passed as the case. Issue notice, how much time? 60 days?
Lordship.
Issue notice making it returnable on
Right.
23/2024.
Lordship.
Ms. M.D. Bora appears on behalf of the respondent number 234.
Lordship.
Mr. S.R. Borua appears on behalf of the, no,
Lordship,
appears for
1 to 4.
1234. 1234. Mr. S.R. Borua appears for the respondent number 5. Do we have a standing counsel for the Reserve Bank? No.
Reserve
Presently
Bank.
not.
No, they have to take steps. Okay.
As the respondent numbers 1 to 5 are duly represented, extra copies of the writ petition be served upon them on 18/1/2024. As regards to respondent number 6, the petitioner is directed to take steps by way of registered as well as usual on or before 18/1/2024. The petitioner herein have challenged the order dated
5/1/2024.
5/1/2024, whereby the Register of Cooperative Societies Assam had directed that the transaction in all the bank accounts of the petitioner society maintained in different banks to be kept in abeyance until compliance with the directions by the cooperative society. It further transpires from the impugned order dated 5/1/2024 that the directions which were given were that the term bank appearing in the name of the petitioner society has to be removed. The term bank, which have been used in the name of the petitioner society, should not be used with immediate effect. This court have also heard Mr. S. Bottako, the learned counsel, appearing on behalf of the petitioner who submits that the name of the bank and the name of the petitioner society cannot be changed unless the same is done so in accordance with Section 12 of the Assam Cooperative Societies Act 2007. He further submits that presently the cooperative society is under the management of an officer of the appointed in terms with Section 41(6) of the Act of 2007. And as such, it is not within the capability of the petitioner society to call for a annual general meeting for doing the needful in terms with the directions passed in the order dated 5/1/2024. He further submits that the shareholders and the depositors would be duly affected if the interim or if the order dated 5/1/2024 insofar as keeping in abeyance all the bank account transactions of the bank accounts of the petitioner society is not stayed pending disposal of the notice. I've also heard Miss M.D. Bora, the learned counsel, appearing on behalf of the Register of the Corporation Department, who submits that in terms of the order dated 8/1/2024, the Register of Cooperative Society has appointed the Zonal Joint Register of Cooperative Societies Guwahati Zone as the departmental officer for the second time to convene the annual general meeting / the election of the petitioner society and to constitute the board of directors within 90 days from the date of the appointment. He further submitted that for removing the word bank from the name of the petitioner society, the same has to be done so in compliance with Section 12 of the Assam of the Act of 2007. And thereupon forwarded to the Register of Cooperative Societies within a month from the date of adoption of the resolution for registering the same. She further submitted that as per her instructions, the departmental officer would try his best to complete the said process within 60 days from today.
Okay.
This court is also This court has also taken note of the communication dated
Thirty 11, 26.
one 8/2017, as well as the order passed by the division bench of the learned division bench of this court, dated 1/9/2016, in TI number 33/2010 and two other petitions, wherein there was a direction to take appropriate steps to remove the term bank from the nomenclature of the petitioner society. However, the same has not been done. So, taking into account the above, this court, however, is not inclined to say the operation of the impugned order dated 5/1/2024. So, be that as it may, this court grants the liberty to not to use the nomenclature of the. This court also have taken note of the impugned order dated 5/1/2024, whereby the register of cooperative societies have passed that direction to keep the bank account in abeyance. Bank accounts of the petitioner society in abeyance, transactions of the bank accounts of the petitioner society in abeyance, keeping in view the interest of the shareholders and the depositors of the petitioner society. So, taking into account the above, this court is not inclined to stay the operation of the order dated 5/1/2024. However, this court makes it clear that any shareholder oblique the depositor, if so agreed by the order dated 5/1/2024, would be at liberty to file appropriate application in the instant proceedings seeking modification.
I'm deeply obliged. My lord, may keep my instructions as part of the record.
Not necessary.
Lord, deeply obliged.
Lord, in this case, my lord, the petitioner, my lord, filed this jurisdictionally. My lord, what happened, my lord, in this case? Petitioner, my lord, the person purchased a vehicle, here, my lord, under the finance, my lord, respondent number 6, and the loan agreement was executed, my lord, the government, and the loan was also, my lord, disbursed at government, and the purchase the vehicle, my lord, also, my lord, here. But, my lord, the some, my lord, amount, my lord, was not paid, my lord. So, my lord, the respondent number 6, my lord, filed, my lord, complaint case for the, my lord, metropolitan district, my lord, at Calcutta. And accordingly, my lord, the summon was issued, my lord.
So go and appear. Summons have been appeared.
My lord, there is, my lord, one judgment, your lordship has also passed, my lord, that
There was a warrant issued. Then warrant issued, obviously we will take note of something. But what if the summons have been issued, then the next date is fixed on 14th for appearance. Go and appear.
But in the humble submission, my lord, there is no, my lord, any, my lord, if cause of action arises, my lord, here.
May arise here, but then also the cause of action there also it may arise.
Prior things, my lord, in here, my lord, cover. Loan agreement was executed, my lord, cover, my lord. Loan was disbursed also, my lord, cover, my lord. He was paid, my lord, but some, my lord, is financial difficulties, my lord, was not.
So couldn't you then file proceedings out there in Calcutta? That court does not have the jurisdiction. Because that is a case of not, it is not a case of that no case is made up. It is a case where that court does not have the jurisdiction. Yeah, the direction is for you to appear on 14/3/2024. Appear.
Your lordship, my lord, can request another visit draft for
Where is the complaint?
complaint, my lord. I have not received, my lord, a common or
Go there. How can this court set aside the entire proceeding?
42, my
No, how can the court set aside the entire proceeding? Yes, 227, 226, this court has the jurisdiction in respect to those matters. There's no quarrel with that. Because of the, if a part of the cause of action happens out there, this court can, taking into account the judgment in Navin Chandra Majitias. No quarrel with that. But the fact remains as to whether a case is made out under 406, 420, 120B, 34. Without looking into that, how can this court set aside that complaint? And are you saying that there is no part of cause of action as a reason there? You see, the court and bench in that case, which you have enclosed out here, was taking into account a particular order whereby there was a warrant of arrest issued. And it is under such circumstances, notice was issued and the warrant of arrest was stayed. How can the entire proceeding be stayed? At least he shall not act upon the warrant of arrest issued by the court of the so-and-so in complaint case number. This is the order at page 48. That
yeah, okay, then, my lord, this honorable court, my lord, also passed an order, my lord, my lord, the death case also, my lord, common was.
so how can you stay the summon unless we say that there is no part of cause of action without hearing the other side?
My full submission, my lord, there is no, my lord, any.
As of now, there is no. How can you say that there is no cause of action? You may have gone out there. May have applied out there. Nothing has been brought on record. You have taken a loan. You must have applied out there. You are only on the ground that there is no cause of action at all out there. Then the question is different. But can you say that on the basis of this without hearing the other side? You are not challenging the whatever it is. The complaint, you are not challenging the complaint on the basis of on its merits. And in the complaint, we don't know what it is written out there. Isn't it?
Yes, Lord.
Yeah.
The loan statement I have annexed, sir. That is, my lord, page 19, my lord. Amount was, my lord, 3,47,000. EMI was, my lord, 29,000. 29,320. Duration, my lord, date is 5/11/2020, 5/9/2020. Still, my lord. The duration, my lord, period, my lord, that is up to 5/9/2020.
Anyway, you have time. Next date is on 14/3/2004. You issue notice. That's a notice we will keeping the jurisdictional point of issue notice, making it returnable on 16th of February 2024. And why you have made the state of Assam a part? What business do they have out here? Tell me.
Till now, upon, my lord, on the
What?
police station, my lord, my
No, they have to do it. That is their function. But what is wrong with them? Why are you making the home principal secretary, home and political department, director general of police, officer in charge, Chipsagar? How is it relevant to make all these people a party?
Earlier round of litigation, that execution part of warrant was there, but at this stage, we don't have any. So
Issue notice upon issue notice upon the respondent numbers 4, 5, and 6. And why are you making the state of West Bengal a party? Because the proceedings are there. And the commissioner of police, how? Kolkata? Why? Isn't this a complaint case? The complaint case, at best, the state can be there. Nothing. Issue notice upon the respondent number 4 and 6. Returnable on 16th of February 2024. The petitioner is directed to take steps by way of registered as well as usual. And what address you have put? How can they serve it? Howrah. Principal Secretary, Judicial Department, Howrah. There is no better address. Eh? What do you do in a quashing proceeding? Against in a private complaint, what do you do? How do you challenge it? You have to make the state of West Bengal or particular state represented by what? Why are you making the judicial department a party? You bet one thing. Let it come up before next week. Before the other bench. Who is going to take up this matter and pass an order? List the matter on 19-1. At the request. 19-1? Thereafter again it will fall to me. You may be again in difficulty. Yeah. Matter on 19-1-2024 as per the yes.
Lord, the cancellation of the applications, my lord,
Ah.
and the consequent, my lord, cancellation of the process for reclassification of land by the deputy commissioner is undertaken. Now, my lord, I may hand over the statute, my lord, holding the field, as well as, my lord, a circular of the government, my lord, of central government. So, in fact, 2015 Act, my lord, the Assam Agricultural Land Regulation of reclassification and transfer of non-agricultural purpose, 2015, my lord, is, my lord, holding the field, and more particularly, Section 5. Section 5 says, my lord, then applications should be made before the deputy commissioner, and he will invite, my lord, report from the circle officer and the, my lord, local authority, which will include, my lord, the Gaon Panchayat, etc. Thereafter, my lord, basing on the report, a DLC meeting will be held, district level committee meeting, which is comprised of the deputy commissioner himself, my lord, as the chairman, and other members. And thereafter, my lord, the deputy commissioner may either deny approval or he may accord an in principle approval. Here, my lord, what the deputy commissioner did, after consideration of all the reports, my lord, this was placed before the, my lord, DLC, and DLC, my lord, in fact, had approved the reclassification of land, my lord. And that your lordship will find the meeting was scheduled, my lord, on 2023, page 74, Annex 5, my lord. And this is the minutes, my lord, of at page 75 of the DLC, my lord. And it was eventually, my lord, that was approved. And page 77, my lord, list of NOC approved by deputy commissioner to be placed before DLC. That was approved, my lord, in this meeting.
2012-2023. And virtually, my lord, this reclassification process attained finality, only short of, my lord, the NOC to be issued by the Deputy Commissioner. Now, when it was undergoing, at that point of time, my lord, a letter came to be issued by the NHIDC, my lord, at page 79. 2124 letter, my lord. This is addressed to the District Commissioner, my lord, by the Deputy General Manager, NHIDC. It reads as follows, my lord. May I read it? 2124. Status of lands for publication and 3A notification. As you are aware, NHIDCL is undertaking 4 laning of Badarpur so of land, and land acquisition for the same is under process. My lord, 3A notification is yet to be, my lord, issued. It has not been issued, my lord, notified. It has come to notice of this office that commercial diversion change on in class of several lands have taken place till date. There is a high probability that landowners might have intentionally applied for change of land.
All understood, Mr. Talukdar.
My lord.
But what order can be passed today?
Lordship may issue notice in the meantime, my lord, what I'm submitting, my lord, this is a time, my lord, the part process under the statute. So eventually, my lord, if the delay, my lord, which will make cause prejudice to us, the limitation may come in our, my lord, interest. So at this stage, my lord, while issuing notice, Lordship.
So you are only concerned with the limitation. No, we make it very clear that the pendency of the writ petition shall not be taken into account while computing the period.
My lord, our premium may be accepted.
What premium? That has not been done. Till now, it has not been finally decided. It has only been recommended. Then?
No, my lord, under this statute, once, my lord, it has been recommended by the DLC, my lord.
The DC has to do it.
My lord, in fact, after our premium is accepted, DC will issue the NOC. Now, DC has not accepted our premium. My lord, this impugn order has come.
So you want this court that the DC should accept the premium on the first day without the hearing the other side.
No, I'm not on that.
Then
My lord, only, may I please, my lord, only proposal has been given, not accepted by any respondents or DLC, not yet accepted, my lord. And after this notification, they have rejected.
when did you apply?
My lord, what has happened now, my lord, the electronic mode, my lord, is accepted. My lord, it was introduced, my lord.
You
late,
applied in 2023.
my lord, 23 first part, my lord. Manually, we have applied, but it was not accepted. There is a letter also, my lord, it was not accepted. Since, my lord, the portal was not active, my lord.
You submitted on 5/12/2023.
This is online mode, my lord.
So that
Yes.
is the only mode nowadays available. Isn't it?
Yes, that is correct, my lord.
Then you want 5/12. Everything is being done.
No, my lord, 78 says that the circle of
Where is the district commissioner has said that the DLC has said that you have that this should be granted.
My lord, if your lordship comes to page 78, the circle
70?
officer has been asked, my lord, to assess the land premium.
So that is format 78.
My lord.
With reference to, I am directed to request you to assess the premium of the land proposed for reclassification from so-and-so to so-and-so on the basis of the missing zonal valuation of the land proposed to the government for approval under so-and-so. The proposed missing zonal valuation of land should not be applicable for any other purpose such as for acquisition of land, etc. till the receipt of approval of the. So, okay. As before Bihu, I think notice can be issued.
Passed, how can it be premature? Our application has been cancelled.
And you want to stay there.
So let's start that, my lord, after the.
When can you get your instruction? All are represented. Issue notice making it returnable on 29th of January. 29th January, you just get your instructions out there. On that day, we'll consider the interim. Issue notice making it returnable on 29th of January 2024. Mr. R. Bapujari appears for response number 1. Mr. Ms. Bielsin appears on behalf of respondent number 2. Mr. S.R. Boru appears for respondent number 3, 4, 5, and 6. as the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. So the case of the petitioner herein is that the petitioners have duly applied for reclassification of their land from agricultural
My lord, to industry.
to industrial.
Right.
And the said process, it is relevant to take note of that the said application was submitted by online mode on 5/12/2023. Be that as it may, a process was initiated by the concerned respondent authority, by the respondent revenue authorities for reclassification of the land of the petitioner. However, on the basis of a communication issued by the
NHITC page 79.
Deputy General Manager of the respondent of the National Highway and Infrastructure Development Corporation Limited, an order was passed as alleged on 8/1/2024. An order was passed whereby 19 numbers of applications, including the applications filed by the petitioners for reclassification of the land under the Nilam Bazar Revenue Circle, was cancelled. The petitioner herein have sought for stay of the said order dated 8/1/2024 by way of an interim measure, and have also sought for appropriate directions to the concerned respondent authorities to further proceed with the process of reclassification. This court is of the opinion that for passing such order without taking note of the specific stand of the respondent authority would not be in the interest of justice. Accordingly, this court shall consider the interim prayer on the returnable date. The respondents shall obtain their instructions in the matter and place before this court on the next date.
Next item, Kim.
Date application on 5/12.
11, madam. That is 11.
The name of Mr. G.R. S.R. Borua, appearing on behalf of the government, state of Assam, be reflected in the court.
My lord, application date little bit different, my lord.
Now the online?
Yes, online.
5/12.
Yes. My lord, that paragraph 5 we have stated 11A application date online.
Online is when? Earlier it was 5/12.
Online 1/12, man.
1/12. Second one 1. 1/12. 60. Yes.
My lord, we have approached the criminal side or the criminal side praying for bail. But here we'd like to show, my lord, the procedural safeguard.
So whenever you get out, they put you inside. And you want your entire prayer is that you have to know how many cases.
Me. And it must be informed to your lordships when my bail prayer is considered. In spite of that, if court grants me bail, thereafter they cannot arrest again. That's the underlying part. But tomorrow, now there are 4 cases. In 2 cases, I am on bail. Just now, my lord, in other 2 cases, bail prayer was heard. Order has been deserved to be passed. Tomorrow, if the bail is granted, they might arrest me in another case. And all the allegations are, my lord, that I have issued certified copy of a deed which is of the year 1992. In another case, it is 1995. And that is, my lord, stated or believed to be false. That one. This is the allegation. Actually, my lord, initially I was issued notice under 160. Idea was I would be made an witness. But I apprehending arrest, I have approached this honorable court. I was given, my lord, an interim bail. Then things started moving.
Yes, who is appearing for the police?
Lordship, I am appearing.
Okay, you will be the commissioner of police will or the DGP will be knowing how many cases are there
Against.
making issue notice making it returnable on 24/1/2024. You have difficulty.
No, my pen would be there, Mr. NB Chaudhary would be there.
Then we can make it later on.
24, of course, I'll not come. I'll
Notice.
come from 8.
Then enough.
Let us get the thing.
Let it be. Let it come on 24.
Because that is the only thing you
Yes,
want.
yes.
Issue notice returnable on 24/1/2024. Mr. S.R. Borua appears on behalf of the respondent numbers 1, 2, 3, and 4. 1 to 5. Extra and accepts notice. Extra copies of the petition be served upon him during the course of the day. So, the case of the petitioner herein is that the petitioner the case of the petitioner herein is that the petitioner's husband, one Sri Ranjit Chaudhary, have been implicated in various cases, including dispute PS case number 384/2023.
2 months.
22 or
2,
20,
the typography is 22.
22. It has been alleged that in various cases, the husband of the petitioner have been granted bail by this court. But whenever but upon passing of the orders for granting bail, the husband of the petitioner is rearrested in some other cases. Under such circumstances, the instant writ petition has been filed seeking information as to how many cases have been filed against the husband of the petitioner, so that appropriate remedial action can be taken by the petitioner. On the returnable date, this court directs the respondent authorities and more particularly the Director General of Police Assam to furnish the details of the cases which have been filed against the husband of the petitioner, Sri Ranjit Chaudhary. Get your instruction how many cases. Then let him file number of bails which may aid and Mr. NNB Chaudhary.
At about 38, order to take it.
Yes, what is this?
I'm for the petitioner. My friend has filed an IA for vacating. The distribution of the municipal fund is on the basis of a population pattern. Now it was population is different in a municipal board. There are 16 wards. Different populations are there, and they want to distribute to an equal way. But it depends upon the population.
What is
pattern.
the stay order? Considering it is directed that in the meeting stipulated on 28/11 no resolution be taken towards distribution of funds, and the FOR will be effective till the returnable date. Then it has been extended.
No, my lord, returnable date is different.
Oh, and you have filed it.
Yes,
So
actually, my lord, they have misunderstood my lord, this my lord, the guidelines, my lord. These guidelines provide this, my lord, as per population of the board, not as per population of the my lord, each ward under the board. They are claiming that, my lord, monetary, my lord, aid should be gone, my lord, to the, my lord, as per population of each board, my
My lord, if I can place one thing, my lord, he is relying on a clause of 3.5. 3.5 says cantonment board. My lord, in a municipal board, cantonments have been excluded under the 56th Act. Your lordship will find it is a cantonment board. 3B, your lordship will find. Cantonment board is for the defense, man. It is not municipal board. He is relying on a clause in the
No, no,
guidelines.
he is relying, my lord, in the retribution on this clause, my lord. Therefore, I have interpreted this.
This is the cantonment board. The code of he has said that 3B has been misinterpreted. 3B is cantonment board. Cantonment board is not under the municipal board. Cantonments are always excluded for the municipal board under the 56th Act. And my lord, the population is on the ward basis. Ward is within the municipal board, and the population is in the ward. So it should be distributed according to population wise. Let the government file an
Who are you?
But I am chairman of the board.
And we are the elected commissioners of the ward.
So what is your problem in distributing amongst, taking into account the population of the board?
My lord, this guidelines, my lord, does not provide so much.
Show me, where is the guideline?
My lord, they have annexed the guideline, my lord, page.
In the stay vacating also they have annexed.
Right, okay. He has given more
Page
interest
15.
to your petition. Yes, Mr. Paul. But one thing very good about Mr. Borgoyai, he really likes to file application after. Yes, yes. Today, anyway, it was for. Tell me where's the guide.
Page, my lord, relevant portion, my lord, there.
The
lord,
page, you are coming to the.
Starting
relevant-
from, my lord, the page 37 onwards, my lord, in the writ petition.
Yes, operator for implementation
Page
of
40,
the
my lord.
recommendation of the fifth finance on the urban local bodies. Yes, tell me then. Clause
40, my lord, B, my lord, for urban local bodies other
B.
than the
40 B. Category 2 cities.
yes, my lord.
Non-million plus urban local bodies other than million plus. The grant shall be distributed to each ULB. What is ULB?
Urban local body, my lord.
On the basis of the accepted recommendation of the latest finance committee, the cantonment.
Cantonment boards are different.
Urban local body.
Case of So it will be taken as 90-10.
Well,
How?
and
In population 90 and 10.
10. Cantonment 10 can give for the population, local population.
Now, is there in any Hailakandi, is there any cantonment board?
No one. No one.
But it is for general. This policy is for general.
For general.
General.
So therefore, where there is no cantonment board, then we are to follow in case of non-availability of established recommendation for distribution within a particular category. The allocation should be on the basis of population and area. In the ratio of 90:100.
Population in the world.
The state should have also make allotment of grants on population basis to the cantonment board. Names and other details of cantonment board are required, provided in. Yes, who is appealing for the union? Union is a party?
No.
You are seeking an interpretation of a guideline of the union and you have not made the union a party?
My lord, I am, my lord, respondent number 8, my lord. They have filed. I am respondent number 8, my lord. They have filed it.
That is why I am asking him on.
Yes.
I may be looking at you.
Sorry, the implementation will be done by the state.
Yes, who is appealing for the urban this SFC, State Finance Commission? Who is appealing?
Finance Commission, my lord.
SFC is the party?
Finance Commission, my lord, no.
The State Finance Commission is the person who is to give the allotment. Huh?
The finance department can do the
Yes, this is because this is being done in view of the provisions of the Constitution. Now, what is your urgency?
My urgency, my lord, because of my lord, this interim order, my lord, work is not in progress.
Not being able to use it.
Guys, my lord, our case is only because the wards are having different population. I've given a chart in page 6.
Hmm.
Your lordship will
No,
find.
no. The problem is, why haven't you made the State Finance Commission a party? It is a body as per the Constitution. It is on the basis of the recommendation being made by the Finance Commission. Plan is being made out there, and from the therefore on that basis, the consolidated fund of the state is being paid out there.
My lord, your lordship permits me, I will file an affidavit along with an impeding application.
You file, but interim orders, how will they function?
My lord, because they are, my lord, at all not.
They will keep account. But something is, but you can't stall the entire.
My lord, they want to now distribute equally. Then if the fund.
Yes, Mr. Borbajari, you appear for the State Finance Commission. Huh? You appear? No. No, not Finance Commissioner. See, there is the problem is that I don't get my books. So the Constitution provides. You see, like for Panchayat, the municipalities also. How do they get the money? They get the money in view of Article 280. This is how allocations are being made. That part is I don't have a constitution with me.
In the base 41 they have been stated that they are considered the finance commission. Finance.
No, it is not required for a constitution. It has to be there. Therefore, it is on the basis of the State Finance Commission this amount that goes. You remember, Mr. Borpujari, that matter pertaining to the Panchayat, where the payment has to be made, remember? So in that judgment also I have dealt with that aspect of the matter. Like it is a similar thing. It is the recommendation has to be made by the State Finance Commission. And it is the body out. It is a statutory body because it has to have it. And he has not made, because here if we are going to go, it is the State Finance Commission who is to make the recommendation. And it is on that recommendation, the amounts will be put in the consolidated fund so that the amount can be paid. This is how it is work.
And my lord.
And both of you have not looked into the Constitution and have filed a petition on population basis.
At the page 45, the board is, my lord, they are going to distribute it by a meeting. Page 45.
Understood. Board will do it unless you know the provision of law. Why will file the petition in this manner? They are to distribute them because without distributing they will also be acting contrary to the mandate of the amount being disbursed to them. It will go for unutilized amount. They will have a lot of problems. That part is I don't have a constitution.
Article 43I.
243 no, kindly come to 280.
Yes.
How it is go? Yeah, Finance Commission. This is. The President shall within 2 years from the commencement of this Constitution and thereafter at the expiration of the every 5th year of the month consider necessary by order constitute a Finance Commission which shall consist of the chairman and the Parliament may by law determine the qualification. It shall be the duty of the Finance Commission to make recommendations to the President as regards the distribution between Union and States. Then you kindly come to here. Yes. The measures needed to augment the consolidated fund of the state to supplement the resources of the municipalities in the state on the basis of the recommendation by the Finance Commission of the state. So it is on the basis thereof, 283C, this is being done. So this is again a statutory body.
Correct.
So who is going to tell this court that this is this or this is that? You have not made the Union of India. You have not made the State Finance Commission a party. How will this court adjudicate?
My lord, your lordship may pick it on 19th, my lord, I will keep it as a implementing party. Well, let then there be distribution. Otherwise, my lord, total case become infected. My lord, let it be on 19th, my lord.
No, the money is not going, it is not a one-time thing. Money will keep on
Well,
coming.
they have already decided that the money will be distributed at a time equally to all the work. Equally to all the work.
Understood. Let them, whatever may be, if the money is not being utilized, it will again go back. Because then they cannot give the utilization certificate, and because of the stay, the amount will go back. It will have again
19th, your lordship will pay. 19th, your lordship will pay. It is BU, they will not do anything. My lord. Your lordship may pick for 19th, will your lordship may keep it parted also.
Why should I keep it parted?
Because
I have enough parted to be heard about.
your lordship may fix it on
First of all, your petition is not maintainable without the State Finance
That is
Commission
why
of
I'm
party.
saying, my lord, let it be on 19th.
For one ward, my lord, 16, my lord, what is told.
Huh?
That is,
For one ward, my lord, other 15 are also deprived.
so he is not representing the other one.
I am board man.
No, I am not worried about the other thing. I am more worried about the fact that this money, if this court stays it, will lead to money getting lapsed, which will have a serious consequences.
But it will be on 19th because his BU, they will not distribute anything. Let it be on 19th. Your lordship will consider on that. Or in the opening also, well, on 18th.
Okay, at the request of Mr. P.K. Roy Chaudhary, the matter stands adjourned to be listed again on 19.
My lord, 19, I have, sorry, my lord, some problem. On 22, my
On 22/1/2024. The interim order passed earlier shall continue till the next date. Be that as it may, the proceedings, the instant writ petition shall be listed in the column of stay vacating, taking into account that there is a stay vacating entity.
Compliant.
Economy. Yes, where is the other side? You want to be impleaded?
No, my lord, they have filed an application for impleading UCO Bank. I am for the respondent number 1. I am the original writ petition. In my writ petition, he wants another bank to be impleaded.
No, this is being filed by some Vantage Point Communication.
Yes, he is the private respondent.
Okay, none appears on behalf of the applicant on call. So taking into account the above, the matter then adjourned to be listed after in the first week of February. Good. What is this?
Application for
Impleading where?
impleading in the contempt case.
Whom you want to implead?
Lordship, previous incumbents of the departments who retired
Huh?
Lordship, we are to implead the new officer.
Maybe please to consider the applicant. Whom should we implead?
Lordship, the respondent number 3 and 4.
As the present officers, Povitra and Nia are holding the post in charge of the office concerned, and they are required to comply with the order dated demand passed by this court and upon communication of the not showing any sign. Victoria, Secretary to the Government of the Irrigation Department. What is the order passed?
Lordship, may find the order
Huh?
page 15.
What is the order?
Page 15. At page 15.
Contempt of which order? Page 50.
15, 1, 5. In my in the IL.
No. Which contempt against which case you are filing contempt? Which order?
Lordship, the thing
2/2015. Where is that?
2015 is the page number 15 or in the IL.
No. In the main petition, where is it?
In the main petition. That is annexure L, last page.
Huh?
62. Annexure L.
Annexure L.
Sorry.
The counsel for the respondent submits an inquiry is conducted regarding the construction done by the petitioner, and after inquiry, if the petitioner is entitled to any money, it would be paid. The petitioner accepts the in view of the above petition goes, the respondents are directed to complete the exercise of inquiry and pass final orders regarding the entitlement of money within a period of 6 months
This
from
was
today.
not done, Lordship. Then we have again filed one this contempt petition 176 of 2016, which is pending. And in
For
this,
what? For this.
for this.
Then why there are two contempt petitions?
Lordship, the thing is, first there was the subject matter is non-payment of contractual bills. Then we filed one. This is in the second round of litigation, petition 2014, wherein the order is a page is in the annexure D. That in that order there was directive from the court to verify the claim of the petitioner and to do the same within 6 months. That
Then
was
you
not
file
done.
this contempt.
Then the contempt.
So now a contempt against another contempt order. Very well.
And in that article.
They would not do anything like keep on changing. You don't have the contempt. Who is appearing for the other respondent? Nobody is appearing till.
Previously, Mr. B. Ahmed used to appear on it,
Ah.
but
But this court have not struck off their names.
Lordship may do the struck off the names of
Then if these people, Kudendra Doloi, Commissioner and Secretary, Government of Assam, Irrigation Department, Mohendra Mohan Boro, Chief Engineer, MI, Irrigation.
They were the previous officers, Lordship. They have retired or super.
They have retired, but they were supposed to do, na?
Yes, Lordship, they have.
So we'll get hold of them better off. That is the best way.
Lordship, now they the present.
You want with the money or what? By this way, it will be a never ending process. We don't have the irrigation council now here.
Lordship, we have given the representation also in the month of October.
Where is the irrigation council? Anyways, it will be an unending affair. You make the party and all. Okay, the instant application has been filed by the petitioner seeking implement of the present secretary to the government of Assam Irrigation Department, Sri Povitra Ram Khan, and the chief engineer Irrigation Department, Sri K.M. Gopal Sana Rajkumar, as the respondent number 3 and 4 to the present contempt application, accompanying contempt application. This court have duly taken note of that the petitioner, on coming to learn about the order being passed, about the change, and about on coming to learn that the respondent number 1 and 2 had already demitted their respected offices. Demitted or transferred? Have demitted their office, have taken appropriate steps by issuing notices to both Sri Povitra Ram Khan and Sri K.M. Gopal Sana Rajkumar on 19/10/2023, which was duly received in their respective offices on 20/10/2023. In spite of the fact that there has been no compliance to the order dated 2015 passed in contempt case number 394/2014. This court is of the opinion that it is a fit case for impleading the said Povitra Ram count Secretary to the Government of Assam Irrigation Department having his office at Dispur, Guwahati 781006, and Sri K.M. Gopal Sanar Rajkumar, Chief Engineer, Irrigation Department having his office at Chanmari, Guwahati 781003 as the respondent number 3 and 4 to the accompanying contempt application. The said the petitioner is directed to submit a fresh memo of parties before the registry of this court, and on the basis of the said fresh memo of parties along with and the order passed herein, the registry of this court shall make necessary changes in the cause title of the accompanying contempt proceedings and also update the same in the CIS. With the above the instant application, it stands disposed. That's filed there by 1819. 19 day. Filed there. Main issue notice to the newly impleaded respondent number 3 and 4 by way of registered as well as usual. An issue notice making it returnable on 23rd of February 2024. Steps be taken. Issue notice against respondent number newly impleaded respondent number 3 and yeah. Returnable on 23 to 2024. Steps be taken by way of registered as well as you.
Number 2 applied in the year 2008. Number 3 applied in the year 2008. On the other hand, the respondent number
You had earlier applied.
Yes.
In 2013, 12 or something.
8 and 9
And the others
applied in the year 2013.
13.
Yes.
And he has been given.
Yes.
Yes, what is your instruction?
Lordship, first, regarding the allotment of the housing board flat, a selection committee was formed to scrutinize and shortlist the beneficiaries among the total 9,000 applicants. Among these 9,000 applicants, the selection committee has selected 900 applicants.
How?
As because there is a selection process, Lordship, at that time.
What is the selection?
Details, Lordship, earlier, the affidavit in opposition filed by the Housing Board Advocate, Lordship, in 2019-3-2017. I have instructed this matter, Lordship. Unfortunately, Commissioner is out of station from 2nd of January, and he will come back to 16th, Lordship. Then I will be clear at this matter. But I have instructed on telephone, Lordship, 19-3-17, the affidavit in opposition filed. And
what is your parameter for 2D? Is it on the basis of
now earlier it was by selection committee. Now in compliance of this honorable High Court order, now there is a draw of lots.
When?
It is started from 2021. To draw of lots.
I am concerned
Earlier,
how you have given these. And who is representing for the respondent, that the private respondent?
Private respondent, I don't know.
Nobody. But they have appeared.
And And Lordship, may I submit?
Hmm.
And Lordship, in this plat in question, Lordship, the beneficiary, he has Srimati Madhumita Boruasen already been surrendered.
Huh?
Already been surrendered.
Surrender.
He has surrendered this plat, and through draw of lot, it was allotted to another person. Right now, this position, Lordship. This is the position, which was over telephone. I was instructed.
And what about 8 and 9?
Lordship.
Now, first and foremost, the question arises,
Lord,
that what is your yardstick for selection?
there is a selection committee to scrutinize all the applicants.
So you are to bring on record those aspects.
Lord.
Then, if he is saying that it is on the first come, first basis, you have not denied to the effect. What is your basis? You have to state in your affidavit.
I have prepared another affidavit, but unfortunately, Commissioner is out of station from 2nd of February.
But
he will be
fact
come on
is
16.
that we are not concerned with others, but your affidavit is not clear. It's absolutely a vague affidavit where you don't say anything as to how you have selected. I hope petitioner herein is aggrieved. Petitioners herein are aggrieved by the actions of the Assam State Housing Board in allotment of flats on lease basis to the private respondent number 7, 8, and 9.
Only 8. Only to the 8.
To private respondent number 8.
8. 9 is the husband of 8 and 7 is the earlier commissioner, is the sister of the respondent number 8. He was the commissioner
Okay.
at the time of
To the respondent number 8. On the ground that the petitioners had applied in the year 2008 and 9, whereas the private respondent number 8 had applied sometime in the year 2013. There are serious allegations being made to the effect that the then chairman of the Assam State Housing Board, who is the respondent number 7, is the sister of the respondent number 8, and out therefore to favor the respondent name number 8, the said allotment was made in favor of the respondent number 8. So this court have also duly taken note of the affidavit in opposition filed by the respondent number 3, 5, and 6. So the said affidavit, however, is completely vague and does not answer to the issues which have been raised in the petition. Mr. T.R. Gogoi, the learned counsel appearing on behalf of the Assam State Housing Board, submits that the said boards would like to file an additional affidavit bringing on record the reasons why the respondent number 8 were chosen, and also answering to the various, and also reversing to the various allegations made in the petition. So this court is also aware of the fact that the instant petition is of the year 2015, and as such, the same requires an early disposal. Taking into account the above, the petition is directed to be listed on 6th of February 2024. In the meantime, the respondent Assam State Housing Board shall file the affidavit by 30/1/2024. It is made clear that if no affidavit is filed by the Assam State Housing Board, the instant petition shall be disposed on the basis of the materials available on record.
31 will remain closed. 31 is not in working date.
30
One is the close.
301.
Lot.
Yes, what is this?
Almost similar lot.
May I please report currently the order dated 1/4/2019.
Yes. What is your stand?
This was this particular allotment was already been cancelled.
Then
now this plate was being taken lot, but not in a position to
so in the 2016 allotment, you have cancelled it.
no lot. This particular plate location, Rita Chaudhary, that when we came to know that she is residing at Dibrugarh, is not residing in Guwahati. And as soon as earlier we issue a notice, and then after selection for allotment was cancelled.
No. How are you saying that this flat or that flat, there is no respondent, private respondent in the instant proceeding? There is no private respondent here. You are challenging whose settlement? Allotment. Setting aside and quashing the impugned list of approved allottees dated so and so under the rental scheme. Which is the allottees?
Rita Chaudhary was allotted.
Now, where is it? List of approved allottees. Bina Soikia, Bimal Soikia, yeah. Why haven't you made these people party? Without them being made a party, how can you entertain the instant writ petition? You are making some allegation against the cancellation. They have some right. The instant writ petition has been filed challenging the allotment, challenging the list of the approved allottees under the rental housing scheme under the Assam State Housing Board at Bhetpara, dated 25/2/2016. At Bhetpara, Bhetapara, Maligaon, and Hengrabari, all dated 25/2/2016. However, a perusal of the writ petition reveals that none of the allottees have been made a party to the instant proceedings. None of the allottees have been made parties to the instant proceedings. Under such circumstances, the writ petition cannot be entertained. As any order passed, entertained in view of necessary parties being not included to the writ petition. This court has also taken note of the affidavit in opposition filed by the Assam State Housing Board. wherein it has been mentioned that as regards one Rita Chaudhary, who was allotted a flat in LIZ, building number E/2 at Ghoramara, she has been already evicted, and the possession evicted. In view of the above facts, to the effect that the petitioners have not impleaded the allottees against whom allegations have been made, and also to the fact, and also taking into account that the respondent authorities have duly taken action against those who have been illegally allotted, this court finds no reason for interference with the approved no grounds for issuance of a writ in the instant proceedings. Consequently, the instant writ petition stands dismissed.
Awesome.
18.
Yes, Tamulpur case.
Yes, ma'am. So on the last occasion, the respondent was directed to update.
Hello.
Investigation has been completed and it has been started.
This court, by an order dated 3/1/2024, had sought for instruction as regards the status of Tamulpur PS case number 244/2016, registered under section 420/468/34 of the Indian Penal Code. Today, Mr. J. Hendrick, the learned counsel, appearing on behalf of the respondent authorities, had submitted an instruction issued by the Superintendent of Police, Tamulpur, wherein it has been mentioned that the investigation in respect of Tamulpur PS case number 244/2016 had already been completed, and two persons, namely Horesor Nazari and Ritua Sirual, Retua Sirulwa, have been charge sheeted, and the charge sheet have been charge sheeted by charge sheet number 28/2018 on dated 28/2/2018. Taking into account the above, the said instruction is kept on record and marked with the letter X. Taking into account the above, the petitioners herein are given the liberty to approach the appropriate court if so advised. With the above, the instant restitution stands dismissed.
And the
Non-payment of compensation of this application of this grant of the construction of National Highway number 154 National Highway.
Then you have not been paid the compensation. Why? Why? There must be some good reason.
It's not captain of my lord. Respondent number 5, my lord, already received a major part of compensation, my lord. But
Who has received?
Received, my lord, respondent number 5.
So your money, respondent number 5 had taken.
That is, I don't know, my lord, but.
Then you
major
don't know,
part
how
of-
can I help you out?
My lord, major part of.
Can you see the paragraph 5 of the
Yes,
petition?
yes.
That at the time survey, the name of the petitioner was not recorded as the owner of the possession of the scheduled land. The petitioner existed, although his major part of the land was taken over by the respondent, but no notice either of acquisition of land or taken possession of the same or finalization has been served to the petitioner till today, and no constitution has been paid.
So it is not the recorded Malad the Patanda. As per Malad, as per here this version, Malad the petitioner's version, as per the paragraph.
That is okay, but does the petitioner have
even
a right over the land?
Even a Lottie may kindly see the annexure 1, page 8.
Azizur Rahman.
Lordship. No father's name, nothing. And Lottie may kindly to the vernacular next one.
Jamapandi is this. No, Jamapandi is there. No, this is whose name?
Lordship, item 25, Malata Azizur Rahman.
Okay, what is the name of the petitioner?
Azizur
Rahman Bordhuya.
And the father's name, na kindly see that.
Where?
There, Lordship. Last, after 27, Lordship. Proceed. Father's name of the serial number 25 is Proceed. Now they have annexed my lord this Jamabundi. My lord, whether is the petitioner's father name is something different.
Next. My lord, I would like to point out, my lord, to one thing, my lord, annexure 2. The petitioner filed a petition notice under section 80 CPC, stating that, my lord, the paragraph 4 of the notice, page 11, they propose to file a civil suit for declaration of their right title and interest. Let him file a civil suit. They are not owner, my lord. Annexure 2, my lord, page 10. The petitioner lodged a complaint, my lord, before the deputy commissioner, and the petitioner's complaint was rejected, my lord. I think, my lord, this writ petition has no merit at all. Their portion is also not specific.
Madam, you file a suit. As per the affidavit, the amount has been received by this Sarafat Ali Bordhuya. Respond number 5. So amount has already been received. Go there, file a suit against him. You can't file it here. What can I do? No way out. I can't even now allow you to go there and seek a reference also.
Yes.
As of now, it is too late. Is there any limitation on the 3H of the National Highways Act? I don't think so. Unlike section 18, which says a limitation is there, that's 3H says. Because this will be a case of apportionment. So this will come under 3H4 and 5. 5 will be only when there is a dispute. No, but see, at what time this has to be done? Now, this is prior to payment. So this is prior to payment. And H5 is, 3H3 is, if there is no dispute, he can make the payment. But 3H5, no, 3H5. Yeah. No, that is, we are not concerned with that. 3H5, 4 and 3H7. 6 or 7, the principal will be which court? No, 3H5 is this. There is another provision, no? Good, good. No, not G, not in G, in H itself. No, 3H4 only. So there is no limitation here. But how would this court have the power for recovery? Yes. The court have the power, they can only decide on the question of apportionment. But can they have the power to have recovery if the payment has been made? I think the only way out will be the civil court. So here it will have to be gone to the civil court. There is no way out because the amount, they don't have the power to recover. It is only to decide the amount. Okay. JK Goswami was appearing. I remember. The instant writ petition has been filed by the petitioner being aggrieved by the non-payment of compensation in respect to the acquisition of his land covered by DAG number 235 and Patta number 185 of what? Of village Bawarghat part 1.
Power part 2.
Part 2?
Yes, ma'am. In schedule portion.
No, it's part 1.
Part
1. It has been alleged that the respondent authorities have wrongly paid the said compensation to the respondent number 5. The record reveals that an affidavit in opposition has been filed by the respondent number 2, who is the district commissioner, Hailakandi. In the said affidavit, more particularly at paragraph number 5, it has been mentioned that compensation against DAG number 235 or Patta number 185 was received by various persons, including the respondent number 5. On 19/1/2013. Taking into account the above, the only recourse which would be available to the petitioner is to approach the competent civil court if the petitioner is in a position to prove his title over the land. He is in a position to only recourse available to the petitioner would be to approach the appropriate civil court. This court had also given an anxious consideration to the and is of the opinion that under such circumstances, the question of entertaining the instant writ petition at this stage does not arise, for which the instant writ petition stands dismissed. However, dismissal of the instant writ petition shall not prejudice the petitioner, if so otherwise entitled under law.
20.
Yes.
My lord, this is third round of litigation, my lord. Before starting the case, my lord, I'd like to draw lordship's attention as order dated, my lord, 21/6/17.
21/6/17. Where?
In the order sheet itself.
There is no 21/6.
2017, my lord. Here, my lord, Honorable Court was pleased to ask them, my lord, to produce the PTCL authority required to adopt the case where the meter is found to be defective for a given period of time. The mechanism they have to show, my lordship has come across, my.
Yes, what has happened here?
Yeah, my lord, the affidavit has been filed, but does not disclose, my lord, what mechanism they
Forget
have.
about the affidavit. Now come to your
Yes,
fact.
my lord.
Why you on
My lord, first, my lord, what happened? The case of the petitioner is that, my lord, a meter box which was sold outside the campus, 32-meter away, found defect, broken, my.
Outside your campus?
Outside my campus, my lord, my campus is there, my lord. Nearby, within campus, you can, lordship can say, my lord.
So that is not your meter.
That was my meter.
How can it be outside your campus?
My lord, it's a commercial, my lord. That's why they have installed out. On the
Okay, then
roadside, lordship.
it was damaged.
They found damage, my lord. They have disconnected, my lord. It's subjected to writ petition. Then Honorable Court asked, my lord, to apply for a fresh, and they have we have to file our objection.
Now they have made an assessment.
They made an assessment. Firstly, that has been interfered by the Honorable Court. Then again, my lord, it was found that, my lord, that was no opportunity was given to us. Then they filed another assessment, which is put under challenge before your lord.
Why should we entertain this petition in view of 127?
Yes, my lord. That question was aroused in earlier round of litigation, my lord. And the Honorable Court entertained the writ petition, my lord.
But that court is no longer there. Is
No longer
retired.
is there.
So I am here.
The
So
lordship
you
is
tell
there,
me
my
why
lord.
should I
Even, my
entertain
lord,
under
having
127?
alternative remedy, my lord.
Yes,
Lordship,
Mr. Pathak.
Lordship, the earlier round, why it was interfered with was because immediately after the provisional assessment was done, the petitioner filed a writ petition. When we called him for a hearing, he submitted a letter saying this matter is sub judice.
So you made a provisional assessment and the hearing under 126(3) was not done?
At that point, it was not done because he refused to come. He said it's in writing. Then, because he refused, we had to pass the final assessment order. Against that final assessment order, he filed a writ petition. That writ petition was entertained on the ground that a person deserves an opportunity to come
So
to
again,
have a
go
hearing.
back to 126.3.
It went back. Then after hearing him, another final assessment order was passed. Against that order, he has come before your lordship on a completely factual ground, your lordship.
So 127.
127.
No, my lord. Lordship will see, my lord. Here, my lord, why, my lord,
That
the
is the-
honorable court was pleased to ask, my lord. They themselves, my lord. They themselves, my lord. Lordship, kindly have a look at page, my lord.
No.
It's a defective meter, my lord.
Defective or not, how can I adjudicate?
No, my lord. From their own document.
I
my lord.
don't have the power.
Their own document. Lordship, kindly have a look for a moment, my lord. Page 61. For a moment, my lord. And my
These documents of effective or not, it is for the authorities to do it. They
My
will
lord.
know.
So
The
for
more delay you do, this is a matter for the last 6 years pending
yes.
unnecessarily.
my lord.
Because they have an interim order in their favor.
So,
And my lord, at this juncture, my lord, we cannot go for appeal, my lord. Statutory period appeal lies for 30 days.
okay, we give.
Apart from that,
can
my
be
lord,
done.
apart
Yeah,
from
you
that, my
will-
lord,
you will not
50% we have to pay, my lord.
That
That
is
has
the-
to be
that is the
that has to be
question.
condoned, my lord. Because, my lord, if I win over,
There are many Supreme Court. In fact, if you see the recent judgment, it's a very important judgment. which
my
has
lord, I
come.
have come across somewhere, my lord.
Huh?
Life law, my lord, even having alternative remedy, even though, my lord, writ petition is there.
No, not necessary. The recent judgment is the judgment in wait.
Regarding the statutory deposit, your lordship.
No. Yeah. This Jaipur Vidyut Vitran Nigam Limited versus MB Power Private Pradesh Limited 2024 SCC Online SC 26.
2020.
This categorically says that paragraph number 130. Wait. Yes. No, not 130. Categorically says. Paragraph 136. We find that the High Court was not justified in entertaining the petition. The Constitution bench of this court in the case of PTC Limited had held that the Electricity Act is an exhaustive code on all matters concerning electricity. Under the Electricity Act, all issues dealing with electricity have to be considered by the authorities constituted under the State Act. As held by the Constitution bench of this court, the State Electricity Commission and the learned so have ample powers to adjudicate in the matters with regard to electricity. Not only that, these tribunals are tribunals consisting of experts having vast experience in the field of electricity. As such, we find the High Court erred in directly entertaining the writ petition when the respondent number 1, the petitioner before the High Court had an adequate alternative remedy of approaching the State Electricity Commission. This is the latest judgment in the Supreme Court.
That I'll check it out, my lord.
Then-
Lordship will do, my lord, one thing, my lord. In the
I will
Electricity
dis-
Act and rule, my lord, there is nowhere mentioned, my lord, what is the mechanism if it is found defective. At not my at cost, at the cost of the respondent. Now, my lord, I am liable for that, my lord. For which, my lord, Honorable Court on the last occasion.
Not last occasion,
Yeah,
6 years
in
back.
That time, my lord. Sorry.
6 years back.
Yes, my lord. That occasion, Lordship has asked, my lord, under what mechanism, my lord, if the
Now
defective
with
is
this new law out there, why should I entertain? Anyways, let it not with Bihu out there. I don't think he should be beyond without electricity.
there? Lord.
Because this court,
No, he has a connection, your lordship.
in time order, I'll vacate it. Na?
Then lordship may grant him some time after he can file the appeal after Bihu, your lordship. Let him enjoy the Bihu and then.
My lord,
Lordship may
can
grant-
it be like this, my lord? Lordship fix the case, my lord, next day, any day, next week, my lord. Then Lordship will pass a profit order whatsoever. Now, my lord, the core issue before your Lordship is that, my lord, a defective, which does not reflect in Electricity Act.
No, if it is defective, they have the mechanism to look into it. I have seen many other matters, I've dealt with it. It is not required.
Lordship may grant him time after,
Tomorrow, in one matter, just for example, I don't know anything about it. I may very well ask Mr. Pathak out there, kindly if I get instruction. Does it mean that because of that, this court is entertaining?
Not that. I'm not asking, my lord, let it be,
The
my lord,
regulations,
any day next week, my lord.
the categorically, the regulations out there, the AREC code categorically deals with these aspects of the matter as to what will happen to a defective meter and how it is to be assessed. It is categorically given. That one.
Yes.
My lord, I'll check it up, my lord. Lordship, give me 1 day time, my lord. Lordship, any day fix, lordship next.
Okay, at the request of Mr. J.L. Borguya, the learned counsel appearing on behalf of the petitioner, matters then returned to be listed again on, now we finish it on 30th, 31/2024.
Lordship.
Interim order passed earlier shall continue till then.
My
This
lord,
is the
can
direct
I-
judgment on
Can
that.
I have a look, my lord, the judgment, my lord? Just one more.
I will give it.
I'll just give it return back.
In fact, this judgment has three very pertinent aspects. One is on the alternative remedy. The other is the interference with tender matters. And the third is the aspect where there are orders which are being passed now. Once you cancel the tender in favor of somebody, the High Court in some matters passes an order for settlement. That cannot be granted. This is the third aspect, which is very relevant. A mandamus cannot be issued for the purpose of appointment. For
21.
Yes, please, sir.
Hmm.
The update that I may be allowed to withdraw the petition with liberty.
Very well. Mr. A.K. Gupta. Oh, this one with liberty.
Yes.
Why?
My lord, what happened is, my lord, this petition is filed to
Ah.
finalize my settlement process as well as the allotment given, if any allotment is given in favor of the respondent number 5 to cancel that allotment. The respondent number 5 is given the allotment on the condition that if the land is not utilized for that purpose, then it within 3 years, then it will be cancelled automatically. That is in the year 2017. That 3 years have already passed. And my lord, my settlement application as per my instructions, the authority is processing. So that's why I may be allowed because at this stage.
No. The order was passed. You have challenged the order dated 5/2/2018, wherein there was an order passed that the land be handed over to the respondent. And that order was stayed by this court.
Yes.
And thereafter, in 2021, this court permitted handing over of the land to the respondent number 5.
But in the year 2018, that stay was already vacated.
No. It is not vacated. Having regard to this, that was a stay which was granted. Interim order shall pass.
But there was an stay vacation.
It was on 30/9/2021, as there is no impediment for handing over of the land by the authorities to the respondent number 5. Accordingly, it is directed that such land be handed over to the respondent number 5 immediately. So, the land was not handed over to him till 2021. How is it 3 years has been completed as on now?
My lord, allotment was made in favor of this.
Understood, but there was a stay by this court.
My lord, stay was vacated in the year 2018.
But there was a direction passed by this court to hand over the land to the respondent number 5 in 2021. Then how is it 4 years being complete? 3 years is complete.
But my instruction is that, my lord, they are now considering the settlement.
Anyway, you want to withdraw?
But
Liberty what?
if something happens, my lord, if again, my lord, some eviction notice is issued or my lord, if my settlement is not made.
So that's a separate cause of action.
That is, but my lord, since there is a prayer to finalize the settlement process in this petition also. That's why I'm saying.
So is it in respect to the same land?
Same thing.
So once it has been allotted to somebody else, if you want to withdraw, matter will be over.
My lord, actually, I'm in possession of that land since 1960, and my lord, since 90.
So why are you withdrawing it then?
My lord, my instruction is that to withdraw as this so that the petition.
Liberty, this court is not going to grant it on this. Withdraw. You want to withdraw. But where is the question of liberty? You want this matter which have been pending from 2018 again come back on fine day.
My lord, if they
This type of granting liberties has a serious consequences later on. Any subsequent cause of action happens, you can very well do. But not in this fact. Mr. A.K. Gupta, the learned counsel appearing on behalf of the petitioner, submits that he has been instructed to withdraw the instant petition. He further submits that he may be given the liberty to refile. this court, having taken note of the fact, permits the petitioner to withdraw the instant writ petition. However, this court is not inclined to grant any liberty in the facts of the instant case. Be that as it may, this court makes it clear that if there is any subsequent cause of action which accrues, the petitioner would obviously be at liberty to file. With the above, the instant writ petition stands closed.
All right.
Lordship, Mr. Esbora will appear in this case. He is on late. It means it's taken after some time.
Yes, what is this?
My lord, I was allotted to work, my lord, for construction workway, because since my lord, no writing deal was prepared, my lord, I submitted an estimate. And my grievance is that, my lord, that estimate has to be considered. So my prayer is to estimate my, consider my estimate.
You want to get money?
Yes.
Go and file civil suit. What is this for? This court shall direct them to prepare estimates.
So just to verify.
Absolutely no. You want to verify and pay.
And yes. My prayer is to just to verify and to ATM if I am entitled for that. My prayer is only.
What do they say?
They have filed an affidavit, my lord.
Secondly, the written has straightforward to approach this court alternative remedy.
They say that
And then Iman issued demand. Answer was compelled to issue notice bearing numbers so and so, the date of the letter. Was time bound since they failed to start the work and was compelled to issue the letter.
Reason for not verifying, they stated paragraph 21 of the affidavit.
Oh, they have not given a completion certificate.
Okay.
Well, it's a fit case for dismissal.
My lord, they said that there is an agreement, my lord, that the arbitration clause is there. My lord, I may approach that remedy.
Very well. You approach.
As per their contention, my lord, that is an arbitration clause.
In both cases?
Yes.
The learned counsel appearing on behalf of the petitioner, order, submits that taking into account the specifics objection taken in the petition, in the affidavit in opposition, that there is an arbitration clause, submits that he would not like to press the instant petition, but would take appropriate steps seeking reference under the Arbitration and Conciliation Act 1996. So, taking into account the above, the instant petition, accordingly, the learned counsel submits that he may be permitted to withdraw with the liberty to approach as per the appropriate remedies available. So, taking into account the above, the instant petition stands closed on withdrawal. However, the petitioner would be at liberty to initiate such appropriate remedies as available under law, including arbitration. The period Petition 14623/2018. Analyze. If so permissible under. Wait, we cannot. No, different law.
Lordship,
Hmm.
will this matter the petition would like to file a reply application?
Want to file a reply? Okay. The learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply to the affidavit in opposition filed by respondent number 2 and 3 on 16/10/2023. Time granted, 4 weeks time is granted.
Objection.
Lordship, here the petitioner was asked to bring on record the work orders. Till date, they have not produced the work orders. Non-payment is a Lordship.
Non-payment?
Yes, Lord. Till date, they have not produced the work orders, Lord.
None appears on behalf of the petitioner and calls for the end of justice. The instant petition stand adjourned. We listed up for 4 weeks. It is made clear that on the next occasion, if the petitioner is not represented, the instant petition shall be dismissed for non-prosecution. Yes, what is this? Oh, that one. Where you were supposed to pay cost. How much? That is the wine shop.
Yes, wine shop.
Ah, your 2 petitioners, 1 petitioner is left. Yes. Tell me, what is it?
Paragraph 7, madam.
Hmm.
Paragraph 7, madam. 6 lines from below.
Hmm.
Even Article 20. I will not.
Hmm.
6 lines from below, madam. Paragraph 7. Even Article 220. Am I with the Lord?
Understood. These are all very well settled principles. I'm not saying in any other case I would have. But the fact that whether other people are at all interested.
But they have given representation before the authority.
So they are not, why they are not following thereupon? Have they authorized you that you approach? The one who was with you have left.
Now, my lord, if the court is of the opinion that there are public interest involved, that my lord, court may convert it into a PIL. If I may rely on.
No, it's not a question of public interest, but the question is very important. Here is an objection. Can one single person object to the having of the particular wine shop?
There are we have given off.
No, I'm not on that. You see that here is a case. If an inquiry is being conducted by the authority, maximum of the people has to be, or some percentage of the people has to be affected. Can it be entertained at the behest of only one person if the other people are not coming? Kindly see. There is otherwise a person can very well ventilate the grievance of many. And in fact, this judgment which has been mentioned is a judgment by which the concept of public interest litigation has been brought in by Justice Krishna Iyer. That is not the issue. The issue is here any wine shop can be very well opened anywhere. But the authorities, as per the excise rules and the act, have to take note of the objections, if any, of the locality. Now, in the locality, if the others are not objecting, why you are objecting? As regards one, if they, because their specific stand out there is they have taken note of the inquiry and they didn't find any objection. So that is the reason why if this court has put this specific question to you as to how is it that only you are there who is objecting.
only the petitioner who is object. They have, the local residents, they have filed complaint.
Understood.
Those are
In fact, your friend out here who is number 2 has also left. Then how this court now has the reasons to believe that others may have also left.
Probably he has been owned by the other particular that
So why not the others? You see, your entire petition was based upon a public complaint,
various
public complaints. Now those public complaints, and of these public complaints, only 2 of them has come. One is you and the other one.
Yes.
Now the other one is left. So whether the other public people have already been owned by the petition, respondent number 6, how do you know? So would it be proper that at the behest of one single individual, this court here, unless you show the infraction to the provisions of the act or the rules? We are not concerned with it cannot be on the basis of an objection. It has to be an infraction to the act or the rules.
a public complaint has to be.
Other public is not here. As per them, the public has already had, there was no public complaint.
To subject to correction, but a person is not debarred from ventilating the grievances of the public.
Understood. But here we are concerned about a host of persons. Because you see, when this act or the rules say the objection has to be from a particular section, a particular amount of people, that this percentage of people are objecting to it, then isn't it justified that there has to be some association formed or something, a selective body being formed whereby a resolution is being taken? Yes, you may not have a registered body, but a resolution is taken to the effect that you can participate, you can file. Very well, something has to be done. A REIT can be very well maintainable. You don't need to have a registered body to be maintainable. But at the behest of one person, can you do this?
But the law doesn't bar him to ventilate the grievances of a common group.
Yes, but can you by yourself take up the issue of the common group if the common group doesn't want you? You have to understand that.
Yes, but now may I submit it like this? Can it be like that other people they join the by way of some time? If that is permitted, I can other
What?
Giving authority for to this person. At the time filing of the request, there were 2 people. The second one has been owned by the other party. So he is dead.
Mr. Ganguly, where is the objection given?
His objection.
No, not his objection. Where is your NOC from the locality?
Locality, my lord, the affidavit filed.
The inquiry was made on 2 occasions by the excise department, and they have submitted a report, but we do not have the copy of the affidavit that they have submitted. It's at page 63, I believe. Page 63, my lord. By the department.
63.
Yes.
Yes. What is it?
Hello, that is an inquiry report, my lord, that has been submitted by the department after a spot verification done at the site.
Copy of the report of the inspector of excise.
Yes.
Full.
Yes.
Annexure F.
Yes, my lord. Annexure A, this is, my lord, dated 28 September 2023.
F. What is the page?
My affidavit is 34.
34.
All these pages doesn't match with what you are saying. Please,
No, my lord, this is 34 annexure A. This affidavit actually was not served.
No, you who is the person who has filed it?
Well, this has been filed.
This has been filed by
Abdul Latif.
Deputy Superintendent Excise Allotment.
Name?
Late Abdul Latif.
Abdul Latif.
Yes, Allotment.
What is the page number?
Starts at page 31.
31. Inquiry into the public complaint of so and so. The inquiry is initiated as per the addition deputy commissioner to cause the inquiry based on here. In the inquiry, in view of the inquiry, spot behavior was undertaken at the job the legal public consulted to ascertain their views on the opening of an license shop in Hawazan so and the total numbers of shares were consulted during the inquiry and they have submitted a NOC citing their favor in the so and so license in favor of so and one of the petitioners was contacted by the other side. Additionally, he has provided a NOC for the issuance of Iman in favor of so and so. The applicant was also contacted in view of the inquiry. He submitted an appeal statement signed by 18 numbers of living within 75 meters of the proposed IMFL shop. Similarly, the Deputy Inspector was contacted in view of the applicant. He submitted a report recommending the application submitted by half of the grant of funds. And in view of the public has no objection on the. So this is being done by the executive magistrate. Why should I not?
Well, because the deputy commissioner had directed an inquiry.
So that
And
has
it was
been done.
and it was one inquiry was done earlier also. This is the second time.
The population of that area is 6,940. Here, my lord, public opinion, my lord, they have consulted 15%. So this 15%, they state that they do not have an objection for the third IMFL on top. There is a judgment, my lord, Tirtha Hazarika, my lord. That says, judgment of this Honorable High Court, Tirtha Hazarika, that says, my lord, to take the public opinion, the best way is to do this newspaper publication. That has not been done. They have gathered few people, 15 number of people who are not representing those 6,900 persons who are residing in that area. Public opinion has to be taken, my lord, through paper publication. This is not the procedure to take a public opinion.
Lordship, objection has to come from the 75-meter radius of the shop, not from the whole of the public.
Ipanath and Tikmalo that he cited, that was in respect of the earlier rules.
Where do you stay? Nearby? The shop nearby? How far is your shop?
I don't
No. How far are you your residence from the shop?
That I can't say now. It is within the Hawazan area.
No. Hawazan area would not do. It has to be within 75 meters, isn't it?
Yes, sir.
Yes.
Then
95 meters.
where is your locus then?
Rule 295.
295.
Under the new rules.
Where is your locus? You are agitating for somebody else.
Yes, and that is not it.
75 meters of the premises involved. Are you staying within 75 meters?
Well, these complainants who have filed the
I am asking you. Others have not come before this court. Are you staying within 75 meters?
I have to take up.
No, you have to state in your petition that you are staying within 75 meters. Then only your objection has to be taken note of.
That aspect is not.
Huh?
That is not stated in the.
What?
How far his residence is from the one proposed one.
Is it near the school? Hawazan Rajohua Natya Mandir.
Yes, there's a distance a lot. Educational institution is about 450 meters.
Huh?
Educational institution is about 450 meters from the shop.
Then no, Hawajan Higher Secondary School and Hawajan Adorsha Prathaming Vidyalaya. He's saying that 40-50 meters from the national highway, 100 meters from there.
This report of the superintendent says this
Because the more I go into it, there's not a single statement that they have a right to file. The council.
Page 105 onwards, my lord, my affidavit in opposition, my lord, the reports, the successive reports of the excise department are there, my lord. Each and every allegation regarding every institution has been given in the reports prepared by the department, not by petitioner, not by this.
Enough. This is too much.
There is a specific report, my lord, 13/11/2019, page 106, running page 106.
And what action have you taken against those wine bars? Against those wine bars, what action you have taken?
Those are already there, my lord. To that effect also we objected, my lord. But
When?
but I've stated in a bit.
When have you objected about the others?
Resident, my lord, they earlier approached this court, my lord. So, my lord, I have annexed the order, my lord. Earlier they have approached this court, my lord. This court said that they were shifted to some other place. The order is there, my lord. At page, it starts from page 57, my lord.
Now, are these wine bars are still in the
Yes.
locality? What actions have you taken against them?
Against them also against those existing, we objected, my lord, but
Where is your objection? Show me. Your objection. Birinsi Borua's objection. Your name is Birinsi Papu Borua.
Papu.
Yes, your Papu Borua's objection. Where is
Birinti has departed. Birinti has left the.
Papu Borua's objection? Show me.
no, objection is not.
I'll fix it. No, Mr. Counsel, I'm fixing it on 18th. File an affidavit. You have objected and enclosed that. We are only on the question of cost. Dismiss. There's no quarrel. These are on remedial measures not to impose cost. List the matter again on 19th of 23rd of January. I give you more time. Search up. On which date the learned counsel appearing on behalf of the petitioner shall file an additional affidavit bringing on record any objections so filed by the petitioner against the other two IMFL off/on shops located within the vicinity nearby to the proposed IMFL off license to be proposed IMFL loss of license to be on license to be issued. You have been issued.
Yes.
To be IMFL also issued to the respond number
7. The hurting part hurt maybe kept because
So it will come before me 2020.
Get it on 29th. After the BUD.
Why? Why 2020?
Not 2022, 29th of January.
Absolutely no. I would have fixed it on 18. 18 too many methods. I'm giving you more time. This is not done.
Tablet.
Yes.
Here, this respondent has filed an affidavit matter. I'm just praying for 7 weeks, sorry, 1 week time matter to file a reply.
And then counsel for the petitioner seeks for an accommodation to file a reply to the affidavit filed by the government. It's the matter after 2 weeks. Yes, Mr. Borua.
I have filed a respondent court at Affluent Authority.
Huh?
It is not.
Well, they have to answer, no notice was served to the respondent again. That they are validating.
Mr. Das, you are appearing for whom?
Respondent number 7, private respondent.
Why? What
So
is
the
wrong?
allegation is against me as regards some building violation, Lordship.
Huh?
They are seeking a direction from the respondent number 4 and 5, Lordship.
Regarding what?
Regarding some building violation that is alleged to have been committed by me.
What building violation you have done?
Lordship, they have actually
You have filed affidavit.
we have filed affidavit.
You have filed replies. Okay. Everybody has filed their pleadings.
Official responded, my lord.
Huh?
Respondent numbers 4 and 7 have filed affidavit.
Who is four?
They're the party brand. They're the next.
4 is the development of it. Chairman, not there.
They are the only person.
Yes.
This is the matter again on 7th of February 2024. On which date? This matter would take some time.
Can be disposed of.
On 8th of February 2028. You want the disposal? Then we'll have it on 2020 for further.
31.
That's right. Yes.
Please, my lords, I appear for the petitioners, my lord. This is a service tax matter. And my lords, we have under previous orders, my lords, a protection against coercive recovery. This was now listed for disposal. And my lords, I think it could be disposed of on a very short point, which is that the order in question is not a speaking order. We had cited board circulars, which well settled by Supreme Court are binding on the department. Those have been referred to, but not given effect to, not even findings to say why they don't apply. There are several other arguments, including the application of a Supreme Court judgment in the case of BDA distilleries, which covers the case. And we had taken an argument that we are not taxable on the basis that we are a pure agent, which is a concept under the service tax law. None of those have been dealt with, my lord. So if my lords would either take it today or give us a short date where it can be listed, I think this may rightly be a case which my lord might look at to see if it is fit for a remand.
Mr. Raha, I think, no? You are
My
Mr.
Rohan Shah, my lords.
Mohan Shah. Mr. Shah, the thing is like this, your counterpart, Mr. Kyle, is not there. He's absent here. So we will take it on some other day. I think the pleadings are complete.
Yes, they are. And would my lords consider the 19th?
When? No,
The
not
19th,
soon.
next
It's
Friday.
not possible. We can have it on 13th, 1-3
Of February.
of February.
Would
February.
my lords possibly accommodate us 23rd January if it is possible?
23rd January, not possible. Too many matters. You have you are already enjoying a stay order?
Yes, yes. So I'll take the lord. I'll take the date which suits my lord, as long as my lords would continue the interim protection.
No, we'll have it on 13th of February, and interim order will extend it till then.
Very well.
Already there, no? Until further orders, it's already there. So no necessary. We will have
But
it on.
my lords would please extend it. I don't want any difficulty with the department. Would my lords kindly extend the interim order?
No, it is already there until further orders. So it is not required. The interim order has been extended until further orders. So it is not required.
Very well, my lords. So then,
so we will have it on 13th of February.
Very well, my lords.
List the matter on 13th of February, on which date an attempt shall be made to dispose of the petition.
Would my lord please just put in one line to say it, earlier order interim protection to continue? it's a tax matter.
If I put that, it will reduce the size. It's already there. Interim order is until further orders. It's not required. Don't worry.
Very well, my lord. Very well.
Affidavit has not been filed by them.
Hmm?
Respondents have not filed affidavit. 2022 matter, my lord.
Getting an affidavit from PWD is not the easy thing, Mr. A very difficult thing. Yes, what is this?
My lord, let this matter come after 2 weeks. I will try to file the affidavit. My lord, this matter is also a little tricky, my lord. He is against this paying GST. So the contention of the petitioner is that the government should pay the GST, my lord. So we have written a letter to the government, my lord. All the respondents, my lord.
Oh, this matter I have already disposed of. Similar matters. This is the matter where the agreement must have been entered prior to the GST coming into force.
No, later on. 2019 is the agreement, and then GST has come on 1st of July 2017.
Then?
Subsequently.
Then what is there?
They are the agreement lost to kindly see. They have mentioned everything, but GST has not been mentioned, madam.
Where?
That additional affidavit I filed, page 103, madam.
Yes, where?
Last one, madam. Clause 41(1), madam.
The rates quoted by the contractor shall be deemed to be inclusive of sales and other levies, duties, royalty, cess, toll, tax of so and so local bodies and the authorities that the contractor will have to pay for the performance of the demand. The employer will perform such duties in regard to the deduction of tax at source as per the applicable law. Yes, then?
So my contention is that, my lord, GST is not mentioned here, my lord. Therefore, GST they have to include in my bill so that I can deposit. That they are not doing that.
This is already inclusive of tax.
No, my lord, that GST is not mentioned, my lord. GST has come much earlier than that, my lord.
So, sales and other levies?
Other levies,
so that's why they have file an affidavit whether sales is covered, GST.
Obviously, it will cover. Why do you need to look into this? This matter is very clear. So,
sales is always GST, my lord.
See? Without an affidavit, Mr. Thor is ready. No, I have already dealt with that case. In fact, that was the very issue that the contentions of the petitioners that earlier it was not there.
Yes.
The concept of GST was not there. Now, what has happened? The rate of tax which was earlier 5%, has now become 12.
12.
Now it is 18, madam.
Or whatever may be, 12 or 18. So because it has become 12 or 18, they want this additional 7%. That was the case. I have dealt with. Now, if it is inclusive of taxes, then under such circumstances, you cannot. Now, this is categorically shows that the price is inclusive of taxes. And when you submitted the amount, you say must have submitted. Yeah. Payment shall be adjusted for deduction of advance payment, security, other recoveries in contract, and the taxes at source as applicable under the law. That is section 39. So, you don't have a case.
That's the only thing, my lord. It's mentioned sales tax, but sales tax means GST.
My lord, we may not,
GST,
when we say tax, my lord.
my lord, GST
Tax
has
on
become
sales,
in
it will be covered.
Levies. Other levies.
My lord, other levies.
Law will pass the order. They can come up with a short affidavit, my lord, then it will be clear,
Yeah,
my lord.
one. Getting an affidavit out there.
No, I'll get it. I'll get it. The 2022 matter, my lord.
Oh, this matter. I think this is another one.
My lord, this Muslim Ali, he has at least 15, 20 cases, my lord.
There's another matter which I have dealt with pertaining
He has so many
to
matters.
forest royalty.
Forest
Yes,
royalty.
madam.
Forest royalty, there I have given it that he will be entitled to the forest royalty.
Yes, sir. That's some interim order I have enclosed, my lord. Regarding the same contract matter, royalty has been included, and his contention was that royalty he will not pay. And some interim order has been passed, and whether it has been disposed of, I don't know, my lord, some other council.
No, that matter I have disposed of forest royalty.
Forest.
Taking into a year. Yes, this matter I have disposed of long time. There's no means
Yeah,
the client has many lawyers.
Many counsel.
Yes, my lord.
My lord, he is one of our prime litigant in PWD, my lord.
Okay. Mr. Adhar, you want to file an affidavit?
My lord, I will file affidavit.
Or you want to say that it is on the question of interpretation? You bring on record his quotation.
My lord.
That will make it very clear. Mr. Ardhar, the learned counsel appearing on behalf of the petition, PWD submits that he would like to file a short affidavit on the point, a lay point. I would like to file an affidavit on behalf of the department. So this is the matter again on 19th of February 2024. The affidavit be filed by 12th of February 2024. The petitioner, if so advised, should be at liberty to file any reply. Yes, what are these? Hello. None appears on behalf of petitioner on call. This is the matter after 4 weeks. In the meantime, you have filed your affidavit.
Yes, I will instruct on it.
You have got the instruction.
Instruction is simple instruction, man.
What is that?
Already process is going on. Here, allotment processes. Maybe discuss of the directing
Allotment of what?
land. Like.
This is allotment of land.
Yes, regarding the allotment.
We'll fix it on some other date then. Let the matter be listed. As none has appeared on behalf of the petitioner on call, list the matter again on 7th of February 2020. Mr. R.K. Musari,
yes.
R.K. Musari, appearing on behalf of the PTC, shall produce the instructions on the next. Yes.
Affidavit has been filed, my lord, by the respondent. Affidavit has been filed by the respondent number 2, my lord.
Affidavit filed.
Yes.
The matter is very short, my lord. SDM oblique election was directed to be held. Nomination papers were, my lord, submitted. Out of, my lord, for 15 members, 14 were submitted, my lord, and they were all uncontested. So, but suddenly, my lord, pursuant to an order, the whole process has been suspended, my lord. Now that order is under challenge before my lord.
Hello, we'll have it on some other day.
My lord.
At the request of the. When did you file the affidavit?
This was filed on
10/5/2020.
11/5/23, my lord.
The affidavit, the records show that the affidavit in opposition has been filed by the respondent number 4. The petitioner submits that the petitioner would not be filing any reply. List the matter again on 12th of February 2024.
My lord, it's respondent number 2, my lord. Respondent number 2 has filed the affidavit.
That is shown as respondent number 4.
That's the video. Video, my lord.
You are appearing for whom? When did you file the affidavit?
11/5, my lord.
That is one 10/5.
Yes.
It is by the copy furnished to me by the assistant register.
I think this is a different 35 and 36.
Your affidavit is not on record.
It is on 35. I am on 35.
Islamuddin.
No,
There's a mistake.
Okay. That was filed on 10/5.
My lord.
By respondent number 4.
My lord, we have already filed the affidavit. It's already.
I've seen it.
My lord.
I mentioned it.
Otherwise, the voters list is ready. Because of the pendency of the petition, the election has not been conducted. So, my lord, direction can be given for concluding the.
No, election is already over, my lord.
There was a stay order.
My lord, we have already been, my lord, nomination.
We'll have it on 12th, no?
On that day, my lord. Oblige.
36 and 37.
May I please, Lord?
My matter is very small matter, my lordship. Page 17 may be seen, my lordship. Honorable High Court, my lordship, on 20/12/2022.
Page 17.
Page 17, para 11 may be seen, my lordship.
Yes.
Therefore, balancing the equities, while the impugned resolution number, resolution of no confidence.
Then what happened?
My lord, thereafter they did not call for the meeting, my lordship. Page, my lordship, page 20 may be seen, my lord. The direction was given to hold the meeting in Patharkari Gau Panchayat at 11 a.m., my lordship, on 17/1/2023, my lordship. But they have called the meeting before the office of Deputy Commissioner, and also, my lord, the meeting was not held, my lordship. Till date, my lordship, they are in contempt, my lord. I have filed contempt petition.
The
also.
contempt
I have filed contempt also, my lord.
meeting was not held.
Not held.
By whom?
By the meeting, it should be held by the before. In
No, who
city
has
office.
challenged? Who has passed this order? Means at whose behest the order was passed?
My lordship,
Islamuddin Talukdar. Who is he? Oh, you are.
I'm the.
Then why did you challenge?
I didn't, my lord. I am the president of the Gau Panchayat, my lord.
And then
I challenge the.
no confidence motion.
Yes, my lord.
By which you were thrown out.
No, my lord.
Then?
Honorable High Court directed for a fresh meeting, my lord.
Were you thrown out?
Yes, yes.
You were
my
thrown
lord.
out by the no confidence
Yes, my
motion. So you have challenged it.
Yes, my lord.
And
it has
then
been
what
set aside.
happened?
It has been set aside by the Honorable High Court, my lord.
So that has been set aside.
Yes, my lord.
There the impugn resolution is endeavored and a fresh meeting for no confidence against the petitioner is directed to be held on so and so.
Yes, my lord.
Such meeting. So the moment it is set aside, don't you become the president?
Yes, but no charge has been given. I am still out, and the vice president is doing the work. And till date, my lordship, they are in contempt. I have been not given the charge, my lordship.
And what is your prayer out here?
My prayer is I should be given the charge, my lord.
Then that becomes why you are into this meeting calling or not?
My lord, first, the writ petition shall be mandama shall not be issued by directive the respondent.
To allow you to function.
Yes, my lord.
And the other contempt is for what?
They did not conduct the meeting.
You should be happy.
Yes, my lord.
And you are filing a contempt.
No, I.
By the way, are you saying that they did not hold the meeting for which you have filed a contempt?
No.
Why? There was no direction to hand over you the possession? Why are you saying that in the meeting here, you went to the venue of the meeting at so and so and waited till however no? Right?
No meeting was held.
No, you should be happy.
Yes, my lord. I am happy. But
Withdraw.
that should be given, my lord.
I think withdraw contempt.
Yes, my lord. I will.
Yes, Mr. So and so, the learned counsel appearing on behalf of the petitioner submits that the instant contempt application has been filed inadvertently would be the better. So accordingly, therefore, the contempt proceeding stands closed on this court have also taken note of that the direction so passed was for holding the meeting on 17/1/2023. 17/1 or 17/10?
My lordship, on
17/1.
17/1.
2023. And the petitioner hearing, the said meeting was specifically for the purpose of holding the no confidence motion, for discussing the no confidence motion against the petitioner. Under such circumstances, it is the opinion of this court that no case of contempt has been made out, for which the contempt proceeding stands dropped. Now, yes, why you have not been handed over? Who are you? Who is appearing for them?
The act, the question that has been raised by my learned friend is that the meeting was not called for. It was called for. The affidavit clearly states.
Where?
At paragraph 4, my lord, page 27 of your lordship's brief.
In the office of Deputy Commissioner.
Yes, my lord.
There was specific direction.
What was the direction passed?
Direction passed before the GP office.
A fresh meeting for no confidence motion
In the
against
office
the
of
petitioner.
Patharkari Gau Panchayat.
Oh, wait. Balancing
2012-22.
against the such meeting may be held in the office of Patharkari Gau Panchayat at 11 and would be held under the supervision.
And
Why did you hold it at the Deputy Commissioner's office?
No, my lord. No, my lord. The language of fresh meeting for discussion convened to be held on 17/1/23 at 11 a.m. by notice so-and-so by the BDO Dulabchera so-and-so. 3 so-and-so was deputed by the Deputy Commissioner in accordance with the aforesaid order dated
No,
2012.
where did you hold the meeting?
No, my lord, that was not held. The meeting could not be held. Why it could not be held, my lord? If your lordship may kindly take up the contempt application, my lord, the affidavit filed therein. That has been just disposed of by this honorable court.
Convened on
Let
17th
me
January.
finish. I did not interrupt you when you were submitting. Don't browbeat at the lectern.
No, understood. Whatever may be. If the meeting has not been held,
My lord.
and as of now, the no confidence motion is not there against him.
Yes.
And there is also the motion, no confidence motion, which was passed against him has been set aside.
Yes, my lord.
He being the president, is he not entitled to the charge? That is the question.
Charge, of course, the act does not provide per se charge handing it over back to him.
First of all, if it is done wrongly, obviously, why do you need the act?
My lord, only thing, my lord, kindly see the counter affidavit filed in the contempt application.
What is that? No,
My
your
lord,
affidavit
he
I have
has
seen.
himself stopped the meeting from being.
Whatever may be.
Meeting
For
from
that, the
happening.
contempt is not there. I'm not on that. I am shocked why he has filed a petition for contempt. The meeting was to be held on 17/1 to remove him.
He has himself
has,
stopped it, my lord.
obviously, he should have done it, and he has filed now
himself
contempt.
stopped it. He has hidden facts from this honorable court.
No, whatever may be, that is a different thing. But as of now, there being no meeting held, then there is no confidence motion against him. There being the earlier no confidence motion which was passed has been set aside. Is he not entitled to the charge of the president?
My lord, the act does not provide, my lord.
Why do the act require to be provided out there? The act makes it clear that you can remove him only by a no confidence motion. As of now, there is no confidence motion. Therefore, he becomes the president. Isn't it? You in your affidavit categorically say.
The meeting was directed to be the meeting.
Yes, the meeting was directed.
called.
Kindly see at paragraph 6 of your affidavit. In this writ petition, that with regard to the statements, I say that following the petition dated so and so, the petitioner, the no meeting of the air was convened on the air was not held. Meaning,
It was
as of
his
now-
petition, my lord.
As of now, there is no confidence motion against him. He is an elected person. Yes, Mr. Sharma. Is it the wrong understanding of this thought?
It was incumbent on the secretary of the Gao Panchayat to approach.
Yes, he should have done it. Or
That
let
has
the
not been
other
done.
members should have taken action if that meeting was not held. But as of now, there is no confidence motion against him. He's an elected president.
Yes.
Well, after contesting elections, spending money. Hello. We'll allow this writ petition. Hand over the charge. When? Who is paying for the respondent? Oh. We'll allow this writ petition and do one thing and direct them to hand over the charge. I'll pass the order later and giving you the liberty to the other members of the Gaon Panchayat to take whatever steps they want to take as per law. Supposed, huh?
Highly obliged, my lord.
Yes, madam.
Lordship, in this case, the lordship, the petitioners have a couple lordship. They are taking permission of court lordship. As in the meantime, husband crossed the age limit of 55 years for IVF treatment.
What do you want?
IVF treatment.
Oh,
Assisted reproductive technology, lordship, there is a age bar of 55 years for the husband.
why a repetition has been filed for this? It is not permissible.
No, Lordship. The act does not permit, Lordship. And this issue is pending before consideration before the Honorable Supreme Court, Lordship. In several of cases, Lordship. The issue is pending before the Honorable Supreme Court regarding, Lordship, the gap of the age, 55 years, in respect of the husband.
She's 55.
Lordship, she is crossed the 55 years,
The
Lordship.
wife is within the bit of the age.
Then
Husband crossed 55, he is now 58. But lordship, my
why do you need the husband? What is this? The procedure is to be done upon the wife.
lordship among the couple.
Both the partners are. And
No. We'll have some other day.
Lordship.
Already affidavit filed.
And even, Lordship, I can place the present status of the Honorable Supreme Court case also in next day, Lordship.
It's the matter again on 9th of February.
Lordship.
Calcutta High Court already granted permission in one of the cases. That also I have annexed.
Understood, but also the question is this court has to basically understand
Even,
this.
Lordship, Honorable Supreme
Other
Court.
things I have no problem. I don't understand head or tail of here.
Even Honorable Supreme Court also not granted the interim order to permit anybody.
Hmm?
Even Honorable Supreme Court does not allow till today the several of writ petition lawsuit. They have paid for interim protection lawsuit. Honorable Supreme Court declined it.
Can it be possible in the month of January itself?
Huh?
Already 6 months left. Can it be fixed in the month of January itself?
January is too crowded. So many matters fixed. Not possible.
Apply.
Apply it. Still one.
Just to file the affidavit. Last occasion, with the lordship at the time, file the affidavit. PDCL.
Oh, PDCL.
PDCL.
PDCL was here very well. No. Okay. Mr. M. Dutta submits that the respondent APDCL have not filed their affidavit in opposition. So, taking into account the above, another 3 weeks' time is granted to the APDCL to file their affidavit. List the matter again on 19th of February.
Well, they have not yet filed any affidavit. Instruction. They took time to write. So everything filed regarding the acquisition of the land, my lord.
What land?
Well, the cultivable land have been taken for the road construction, my lord. As per the Mala project, my lord.
By PWD?
Yes.
I knew it. Things will be done by the PWD. Yes, Mr. Dhar.
So, my lord, here is a case, my lord, the land acquisition, my lord. The thing has to be.
Yesterday there were two matters. I think you too. Yesterday I fixed the matters. Some matters I fixed it. Admission. Supply admission, huh? Yes, that will be required. Yes.
Well, the similar case has been disposed of by the court, 373.
What did it say? No, here acquisition process has been initiated or not?
Initiate.
Then
But we have filed an objection regarding the prices.
It's okay.
They are not listening to us. They
They are not listening. You have an appellate authority. You can very well take it up. They were acquiring under what provision? Assam Land Acquisition and Requisition Act. That is why you do it, or under what provision? And that Mala scheme is a different thing. Mala is only a consent.
This is Mala program. Under
Mala program is a consent. You can't forcefully take it.
But they taking it for
My lord, what they want is they want that it should be under this right to fair compensation.
Ever maybe
That is
that
what-
is a different thing. Mala project, if I am not wrong,
My lord,
can only be by way of a consent.
my lord, they are not objecting to the land acquisition. They are on the rate.
Understood.
My lord.
A rate will be a case when the question of Mala will come in. Because once it is taken under Mala, he doesn't have the right to file an appeal. And you don't initiate any acquisition proceedings. It's a buy, it's a buying of the land. The state is buying of the land. So he may not be agreeable. So you cannot, on the basis of Mala, you cannot take over the land from them. It is illegal. You can't.
My lord, we are the PWD is an executive authority. We just build
Yes.
the roads, my lord. Land acquisition is done by
Mr.
revenue, my
Babujari,
lord.
you come into the scene.
We will just build the road.
How are you taking on the basis of Mala? You can take it away. Mala, I think it's a consent.
Lordship, may be pleased to come to page 33 of the petition. This is the notification.
Yes.
This is land acquisition for direct purchase by way of negotiated settlement. for
It's a
improvement-
negotiated settlement. So
Negotiated.
unless they don't agree, you cannot take it over.
Absolutely.
And where is the question of hearing, no hearing, nothing, all these things doesn't apply.
No.
Either if they don't agree, the moment they don't agree, they will have to initiate proceedings under the Assam Land Acquisition and Requisition Act. That is the mandate. I think that is the 412 or something, if I am not wrong.
Lordship,
Yeah. 4.12. The settlement reached in the negotiation shall be recorded as agreement to B and C for the landowners and for interested other than the landowners. If any restricted, an undertaking may be signed by the landowner declaring that they will not claim for payment of higher compensation in any court of law or any other form shall abide by the sale agreement finalized by the so and so. The said land owners and other interested shall have to provide the electronic so and so. So unless this is being not done, where is the question arises?
no, now whether, my lord, the committee, Lordship will kindly come to page 34. Page 34, there, my lord, will find clause 4. Government of Assam has adopted has adopted land acquisition for direct purchase by way of negotiated settlement for improvement and upgradation of state highways and measures so and so under Assam Mala program and so aided project. The important
Kindly come to 4.5. The owners of the land who may agree to sell the land may be identified and a list may be prepared after ascertaining the actual owner of the land.
before that, Lordship will kindly come to 4.2. The committee, this is important. Before that, 4.1, step 1, these are the steps. The requisitioning department, that is the PWRD, shall finalize the minimum extent of land required for each road project under Assam Mala so. Requisitioning authority shall give requisition to the concerned Deputy Commissioner District Collector in format A. Then step 2, a district level land purchase committee under the chairman concerned DC is to be constituted for direct purchase of land as well as fixation of market value, etc. The DPLC will be constituted with the following persons: Deputy Commissioner, Additional Deputy Commissioner, Executive Engineer, PWD, Executive Engineer B, Building, PWD, Revenue Circle Officer, Sub Register, representative for other departments as decided by the convener. So this is the committee which will, my lord, enter into negotiation with the landowners.
Kindly come to 4.17.
4.17. Yes, step 17.
In the event of any owner refusing to sell the land, or any of the owner has objected or not interested in the direct possessory, the respective land may be acquired through land acquisition process of some right to fair compensation and transparency
Therefore,
settlement rules.
If he is not agreeable, what is this court going to do on the Assam Mala project?
No, but yes. We have received some instruction.
No, what instruction? The entire case is you don't agree, don't take.
No, whether steps have been taken, those people will kindly see. If he may not agree, then alternative might not exercise can be done by the authority.
Yes, take it.
So now, whether that has been done, to that action, lordship may kindly see. If not done, lordship will direct the authorities.
No. First of all, tell me whether they have signed in the award. Without signing on the award, how or in the agreement, can you take it? Have you signed it?
No.
Then how are you passing any awards without that? This is completely in violation of it.
Here, my lord,
you can't take that like that.
Concept of award, my lord, as such is not contemplated here.
No, award is there. Kindly see. Page 34, kindly see this.
Yes, my lord.
Clause step 14, 4.1. The deputy commissioner shall make an award according to the terms of the agreement by so and so.
Yes.
This is the award. This agreement will become, you see, this is exactly in terms with the section 12.2 of the earlier Land Acquisition Act of 1894.
Yes.
This is the award.
Yes.
This is a consent award.
Yes.
So this is a consent award.
Yes.
But this is how they have to be consented.
Yes. Now here the parameters is, my lord, that it will be negotiated. If they are not agreeable to negotiation and the quantum of money, the queue that has to be taken is from, my lord, the provisions of the 2013 Act. That lordship will find it clause number 2, page 34. Now, if that is not done, next recourse will be as per the scheme itself, my lord. 2015 rules will apply, my lord.
No, it is there, look out. If you don't want, don't sign. They can't take over the land. What?
Very true, my lord. We are pressing for that. You pay us fair compensation. They are not giving it the rate they are giving very less, which comparison to other.
It reminds me of this particular fishing thing, na? What they have done is putting it out there like 25% we are giving you more than what you would have got under the right to fair compensation.
Yes, very true.
They say. Now, if you say, okay, very well, let us take up that. And if you are not agreeable to that, then they will pay you at 25% less on the same value. And now you are to fight a litigation.
His instruction says, my lord, that they have not raised any objection regarding the.
That's why you have come over here.
Mr. Borpudari, question of objection, no objection does not arise. They have to sign the agreement. Have they signed the agreement? That is the issue. If they have not signed the agreement, Mala project fails.
Yes. Consensus ad idem.
Yeah.
That is what is going to.
And that becomes a consent award. The learned Mr. S. Bolwa, the S.R. Bolwa, the learned counsel appearing on behalf of the district administration shall apprise this court as to whether the petitioners herein have signed, have executed any sale agreement with the district administration in respect to the lands which are the part of subject matter of the instant litigation. List the matter again on 5th of February 2024.
My lord, yes.
Yes, let me take up that matter. 61, yes.
Both the matters.
Both the matters. You just find out. This is a simple issue. Yes, what you have got it?
Yes,
acquisition proceedings initiated. If acquisition proceedings have been initiated, then you have no case.
No acquisition was.
No, they have. That is what they are saying. I fixed the matter today. That is the reason why, to find out. Now, if any acquisition proceedings initiated, then you will get the money if they take any steps. No. There's no acquisition proceedings initiated.
Lordship may kindly look into serial number 8 of the letter.
No. You have not initiated acquisition proceedings. You are proposing.
Yes, Lordship. We have
No land acquisition have been initiated. So you can't acquire. Don't disturb their possession till you don't initiate.
Lordship, the proposal for
Proposal, whatever may be, you can't take it like this. Unless you initiate acquisition proceedings, don't take it. Even in a case you want to take urgent also, you have to initiate. This cannot happen like this. It has been going on for all these years. This can't happen like this. You can't take it at you. I'll take it and after 20 years I will initiate the proceeding. This is what I'm finding with the Water Resource Department. The glaring thing. You initiate, do whatever may be, get an initiation, then only you do. No, they have not. Because what happens otherwise, it will have a far-reaching consequence, and later on they are not bothered. No. Yeah, hence no land acquisition proceedings.
Some of the petitioner lose their house, Lordship, forever.
Don't disturb them. This court, by the order dated 11/1/2024, had directed the respondent authority, more particularly the Revenue Department, District Administration, Hailakandi, as well as the Water Resource Department to apprise this court as to whether any acquisition proceedings have been initiated against the lands belonging to the petitioner. Full stop. Today, the Learned Counsel is appearing on behalf of the respondents. Authorities have placed before this court various documents which show that till date, no acquisition proceedings have been initiated for acquiring the lands of the petitioner. So under such circumstances, this court directs the respondent authorities not to disturb the possession of the petitioner in respect to their lands till formal acquisition proceedings are not initiated in accordance with law. Initiated accordance with law, and urgency provision is not invoked. The instructions which were placed be filed by way of an affidavit by the concerned respondent departments. List the matter again on when you want to do it. You are the water resource. When?
Huh? On
25th
or February, or in February, in the month of February.
You have to file your affidavit. It's very easy to say.
Lots of February.
5th of February? On 5th of February.